1.
Good morning, ladies and gentlemen. This is the December 3rd, 2025 meeting of the Board of Oil, Gas, and Mining here in Salt Lake City. I think we've got a rather full schedule today. I think we'll proceed with the informal briefing. Mr. Thomas.
Thank you, members of the board. My name is Mick Thomas. I'm the Director of Oil, Gas, and Mining for the state of Utah. Before I get into the briefing topics for today, I would like to take the liberty of introducing our new Deputy Director of Oil and Gas, Ms. Jen Middleton. Please, I'm just going to ask her to wave so everybody can say hello to her. There she is. She's been on the job exactly 5 days now, already making some excellent recommendations and supporting her team in ways probably I was unable to because of the workload. So we're really, really happy to have her on, and you'll be hearing from her, I'm sure, at future meetings. So thank you.
Could I interrupt you just a second, because we also have a new member on our board.
Please.
While we're doing introductions, I'd like to introduce Sandra Margulies. She's our new board attorney, and she also has been here maybe 2 or 3 weeks, so she's brand new to the operation, and you'll be seeing more of her, hopefully.
Yeah. Thank you, Chairman.
Thank you.
And again, we have worked with Sandy and just as high regard for her. We're bringing on some excellent people.
We're expecting really good things from her.
It's going to be strong. We will try to get through the briefing as quickly as possible. I know we have a robust meeting and agenda today. First item, I have asked Natasha Baloff to come up and speak for the Class 6 primacy update. So, Natasha.
Hi. Sorry, I guess I haven't talked today. I'm Natasha Baloff. I'm the Legislative and Planning Coordinator for the division. And a quick little update on our Class 6 application. It's currently the final step before we can submit our application to the EPA is a public comment on the application itself. We've had that open since the beginning of November, and the comment period will close at the end of this week. We will be holding an open house on Monday, December 8th. I believe it starts at, I should have verified this. I'm not going to say a time. It's in the afternoon. But once that closes, we will compile the comments that we received, summarize them, and send our application up to the EPA. So unless you guys have any questions, that's all I have for this briefing item.
How many comments have you gotten?
0.
Okay.
Yeah.
Good. Well, that's good news. That means you've done a good job.
Yeah, and I guess I will say that you can also find all of the application, all of the contents of the application packet online. It's through our board website under the rulemaking tab.
And where was that public comment, or the open house?
The open house will be here. I believe it's in the auditorium. Again, I'm not going to comment on the time.
Okay.
Just
Sounds
I
good.
don't remember.
Is there a sense of after it's submitted how long it takes for primacy with the EPA, or?
I don't know that. I don't know what the time frame is. I know it's at least a couple of months. In some cases, it takes a couple of years. We're hoping that ours goes quicker, but we'll see. We'll see how it goes.
Chairman, Mr. Galecki, I can speak a little bit more to that.
Go ahead.
Thank you. As a co-chair of the Interstate Oil and Gas Compact Commission, I work with other states similar to Utah. Not as good, but still, similar to Utah in our ranking. And it varies. I haven't heard of anything under 12 months. And sometimes, depending on the administration, frankly, the primacy could take, the whole administration. We will endeavor to get it quickly, completed and reviewed. The good thing is this is not a new process to our federal partners, so they should have it pretty well dialed in, and under this current administration, things seem to be moving pretty quickly. So thank you.
I will add one more thing to that. We have worked closely with the EPA while we've been completing all of the individual pieces, so we know that we already have EPA approval on the majority of the application contents.
Are there other states that are going for primacy? Do you know, Director Thomas?
Yes, currently Michigan is going for primacy. I know that. There may be others I'm unaware of, but I know Michigan is in the process as well. Not as far along as we are, probably where we were a few years ago, but they're moving forward with it as well.
Do any states currently have primacy?
Oh my goodness, yeah.
A lot?
Yeah,
There's like-
several.
Okay.
I want to say 8 to 10.
Okay, good. All right,
Thank you.
thank you.
Thanks, Natasha.
Yeah.
Item number 2, during the briefing, the approval of the proposed 2026 board hearing schedule. I trust you all have that. If not, we'll make sure we get it to you. I'm not going to read the dates to you, but it does give monthly meetings as well as deadlines to follow. If there's any questions on that, I'm happy to entertain them now, but it's relatively straightforward. Okay. Under the item number 3, other, there are a few updates I want to give the board, and this is just informational. As you may know, I've missed the last board meeting because I was on the other side of the hemisphere on the Governor's Trade Mission to Australia and New Zealand. New Zealand and Australia in that order. Primary goal for us was to advocate and develop critical mineral cooperative agreements between Utah and Australia. We met with several good operators. We met with some folks who are frankly just mining the industry for money, and we were able to tease out the real from the surreal, so to speak, and those are moving along very well. Utah is actually very attractive to the industry, especially the mining industry in Australia, because our cost of power so far is about a fourth to less of what it costs per megawatt in Australia, because Australia does not support any nuclear development or coal use or oil and gas use for power generation, which makes things kind of expensive when you have a mine in the middle of the continent. Also, believe it or not, our permitting timeline here in Utah is significantly truncated compared to what some of the mines in Australia are dealing with. So that was very positive. A second thing that will come out next week, we have developed a list of critical mineral operations and even a processing operation as well to provide to President Adams with the Utah Legislature and the Governor's Office for support during the 2026 legislative session. We vetted several candidates for that, and we have a list of 6 that are in draft form. I'm not going to speak to them today, but we feel like the legislature could easily support this during the 2026 session. So those are my no oil and gas updates on that, because that show's coming on later this afternoon. But there's the mining side that we can talk about. Any questions on that before I move forward? Thank you. Item number 4, next month's agenda and division calendar. Our next meeting will be, I think, during the first week of the legislative session, Wednesday, January 21st. When does it start? I think it starts on the 19th. At 9 a.m., we'll all be here. It'll be a lot of fun. If you have any questions about that agenda is also before you, but it will be at 9 a.m. on January 21st. Any questions on the agenda or anything along those? Good.
I think it's January 28th according to this schedule. Oh, wait, never, yeah, January 28th.
Mm-hmm.
I know it's one of the latter weeks in January.
Trust him.
It's going to be awesome. We'll let
Trust
you know
him. I
in
think he's
advance.
right.
Sorry. Like, these things happen. Thank you, Vice
Thank
Chair
you.
Walker. Oh, thank you. Going back an item to the board schedule for 2026. We need a motion to approve. Thank you, Patty.
Is there any comment on next year's schedule from anyone? Do I have a motion to approve it? So moved. Second? All in favor, please say aye.
Thank you.
Aye.
And thank you, Patty.
Thank you. The ayes have it. It's approved.
Thank you. One of the final topics, opportunity for public comment. I would like to share that the board, as you do every month, asks and invites public comment with the understanding that there probably will be significant comment on the oil and gas bonding rules as we move into that, probably late morning this afternoon. I think the board is welcome to delineate the type of comment they receive now versus later, but it's at your discretion.
I think we'd like to hear any public comments other than bonding comments, which will be heard as a whole when we finish this formal part of the session. So is there anyone in the audience who'd like to speak on something other than bonding? Seeing no one, I think we'll go forward.
Thank you. And audible right now, Natasha has reminded me there's one more topic that's not on the agenda we'd like to discuss. Go ahead.
Yes. And this is, I will take full responsibility for this, and you can refuse it if you would like. Please don't, but I understand. Back in the February board hearing, we brought some cleanup language for the recycle rules that we did last year. This included updating references that we had. There were some incorrect references in there. There were unused definitions that we had accidentally left in our definition list. And we realized that one of the sections was not needed anymore because we already had that in the new rule. So we had come before you in February asking to make these corrections. You guys had granted that. It went through the 30-day public comment period. We didn't receive any public comments on it. When we were going to come before you again, we actually realized a couple more inconsistencies and incorrect references. So we made those corrections, did another 30-day comment period, and that we were supposed to come before you in October with kind of the calendar being not, we weren't meeting here, we were meeting other places. Anyway, I'm bringing it to you now to ask for a notice of effective date. Again, it's completed its 30-day public comment period, and the last step is just getting an effective date from the board. I'm hoping to get that today. We can have the effective date as early as today. If you don't grant it today, there's a little bit administrative work I have to do on the back end, and then we would bring it back to you in February to finalize it. But I was hoping to get an effective date from you today.
Board, do you have any comments? Do I have a motion to approve with an effective date today?
Just make sure when we approve that we identify specifically what it is, what's like the title of the thing. Like, is this the recycling? What are they calling it?
I don't know if you heard that. Please caption the title in your motion and the effective date. Do I have a motion?
I'll make the motion, but I'll need the title.
What is the title?
This will be for the R649-9 recycle facility rules.
Thank you. Go ahead, Mr. Galecki.
For the R649 recycling rules, I'll make the motion to approve.
And with an effective date today?
With an effective date of today.
Thank you. Do I hear a second? Second. All in favor, please say aye.
Aye.
Got it. Any opposed? Motion carries. Thank you.
Amazing. Thank you.
Okay.
Board, thank you so much for your flexibility this morning. We appreciate it.
Oh, no problem.
That concludes my comments at this briefing.
Before we move into the formal, excuse me, the formal section here, I'd like to just say the board changes chairmanship annually. We like to spread the ability to be chairman among the board members. My time has come to an end with this meeting, and the vice chair, who is Al Walker, will be taking over at the January meeting as chair, and he has selected, the board has selected Gordon Moon as the vice chair. So we're going to trade places here in January, and thank Mr. Walker for continuing here, and he's going to do a great job. He'll do a great job. Okay, I think we've done our housekeeping duties, and we're going to move now into the formal part of the agenda. Thank you, guys. Appreciate it. Docket number 1 is docket number 2025-049, cause number 132-81, in the matter of the request for agency action of SM Energy for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,920-acre drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, or Colton formations comprised of sections 1930-31, 2 South 1 West, USM. This matter has been continued to the January 21st 2026 hearing examiner proceeding, and January 28th board hearing. Then we're moving on to item number 2, which is docket number 2025-050, cause number 132-82, in the matter of the request for agency action of SM Energy for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280-acre drilling unit established for production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton formations, comprised of sections 3031, 2 South, 1 West, USM. This matter also has been continued to the January 21st, 2026 hearing examiner proceeding and the January 28th, 2026 board hearing. Boy, that's hard to say, 2026. Yep. Moving on to item number 3. I think this is a record for starting. This is going to be WEM operating. Docket number 2025-041. In the matter of the request for agency action of WEM operating for an order authorizing the flaring of gas in excess of the amounts allowed under the Utah Administrative Code Rule 649-3-20 from the Arabian 4-4-18-17-7H well, the Walker 4-4-78-8-1H well, and the Shire 4-5-12-11-2H well, and the Clydesdale 4-5-13-14-8H well, with a surface location in Lot 1, Section 18, 4 South, 4 West, USM. And please note that WEM has met their commitment and will not be appearing at the hearing today. So this matter is now closed. Moving on to item number 4. This is docket number 2025-046. Do we have the parties wanting to come forward here for this matter? In the matter of the request for agency action of Walter S. Fees Jr. and Son, Oil and Gas, for an order requiring an accounting and payment of proceeds from ARB Energy Utah, LLC. Your hair has gotten shorter. That's okay. Could I have the parties identify themselves, starting with Mr. Fees, I'm assuming? Thank you. Thank you.
Morning, everyone. Peter Donaldson for ARB Energy Utah, LLC.
Thank you. Division?
Assistant Attorney General Andrew Haynes on behalf of the Division Oil, Gas, and Mining, and I'm joined by Brittany Wallace. She's the Division Auditor.
Thank you. Mr. Fees, would you like to proceed?
Can you turn your mic on and move it close to your mouth?
Just move it. Yeah, move it closer. I think it is on. It's just,
About 3 or 4 inches away.
okay.
Yeah, I disagree with the settlement that ARP wants to do because I don't think their bookkeeping is correct at all. And I don't know this for a fact, but it looks like they've been through 4 bookkeeping systems, and I don't know how many bookkeepers they had. I'm sure that Lauren Meeks can do this, but I think there's more to this because since ARP has taken over operations, we haven't made any money. And before ARP took over, when Lone Mountain, Jim Routson ran it, we each made about $10,000 a year. Now we make about $1,000 a year, if that. Routson had it in the time when natural gas was 89 cents. ARP has had it when it was $8.90. The other thing, ARP has taken our properties, and whether he wants to admit it, he has taken loans out on them through Utah Energy Traders. And I brought the documents showing it, but also he took out a $1.2 million loan, and he took out a 1.2 and a $5.2 million loan through United Traders, which he can't do to our properties. He's taking the overrides on working interest people and paying off the expenses. He can't do that. His volumes don't correspond with volumes shown on the 2014s or the working interest statements or to the state. His books are messed up. And somebody needs to take care of it. Brittany did a very, very, very good job of trying to come up with a settlement. But the problem is there are so many things wrong with his books that what you have to go back to are the 1099s we received from Routson and the 1099s we received from ARP, and use what the average is over the years. And that's the only way you can. Nobody can figure out this system. I mean, it's a basic mess. And there's a whole bunch of people responsible for it, and there's a whole bunch of contracts that somebody should be looking into as an attorney general to see if there's some fraud here. So I will be more than happy to give you what I brought for a handout, which is a copy of the Duco bill, and I use this as an example. And the reason is, if you look at the State 2.5, the 216 Hancock, the Bar X3, the same prices are used on all those for Duco. And the question is, what did Duco do? Those wells weren't worked on. Duco's a service rig, dirt contractor, or not dirt contractor, but service rig. The one that is maybe even correct is the Valentine 4, which they actually worked on. But you can go through this with the context bills, the bills from Ace High, and all bills. All he did was take the bill and allocate it to every well, whether the well was on or not. If you look at the Harvey X1, it got charged for water hauling, and Brittany had that reversed, but it hasn't been on for 2 years. It doesn't produce water. So the other thing I have here is a copy of United Energy's statement. And if you look at the gas price on here, it varies. This one I didn't do, but the one I had 15 volumes and 10 volumes and 15 different prices. Now, this to me states that he's hedging my gas, which he can't hedge my gas. You got a gas price on this one from $2.17 down to $1.71. The one I looked at was a little different, but they're all like this. Now, how can you have in 1 month 15 different prices? You can't. You have the gate price of what you get paid, and that's it. Then the other question, the other thing that's on here are the 1099s that I received from Routson and the ones that I received from ARB. So, and this is the third one. This is the loan for 1.2 million. And the funny thing is, the marketing price is -5, but the carrying cost is 66 cents. They call this a prepaid. I don't know how you can have a prepaid when you give somebody 1.2 million and then you charge them 71 cents a MMBTU to pay for it. So I have a lot of questions, but I don't think you want me to ask them. So I'll call that good right now. And there's other things you can bring up. I mean, I think what Mitch said on his last meeting that this is a Ponzi scheme. Mr. Humberto has how many companies? 32? Has how many lawsuits against him? 16? So that's my last comment. So do I hand these to you guys?
I don't, have these been provided to ARB and to the division?
They can right now.
Yeah, I think you need to pass it out to both of them so they can have a chance to look at what you're presenting.
Go. Do you want one, Brittany? Oh, we're good.
After you've had a chance to review the information, Mr. Fees, would you like this admitted, this as evidence?
Yes.
Could you provide it to the board
Yes.
also?
Mr. Fees, if I could get a copy, I'll get them filed.
I've got 7 copies.
Okay, that's
There's one.
okay.
Mr. Donaldson, do you have any concerns about this being submitted as evidence?
I do, in that at least one of these documents I've never seen, and specifically the first page that he handed me of averages, which just isn't really relevant to the issues. And frankly, none of it is, so I do object on that basis. It doesn't show what he's saying, and the divisions looked at these issues, so I do object for that reason.
Let us look at the information and then we'll decide.
I do not have enough copies.
Okay.
Can I borrow one back?
Yes.
Thank you.
We can maybe share the copies here if there aren't enough. Yeah, that's fine. Al, you and I can share one. Hearing Mr. Donaldson's complaints, does the board have any problem with admitting these or not?
I think it's some evidence, so we should probably, even though it could be his worksheets, we should consider these things.
Okay, we will admit it
Okay.
as evidence in this case. And now, I guess I'd like to ask Mr. Fees, what is your expectation here from this board hearing?
Well, I think that doing it this way is the fairest way to do it with the 1099s because it gives you.
Your mic's not on, or you're not talking into it.
Yeah, that's good.
I think the fairest way to settle this issue is to do this with using the 1099s and doing the 6-year average for Lone Mountain and the 6-year average for ARB, and then multiplying it by the 6 years that ARB underpaid us, and deduct the 6 years of what they did pay us, and that's what we'll settle for, which would be about $56,000.
Were your production volumes very similar throughout all of that time?
They should be flat. They're gas wells that are 50 years old, 100 years old. They're flat. The only change they had in them was when ARB did the Surge Tech deal, brought more water in, and for a 6-month period, they had to clean themselves up. We went from 0 water to 5 to 9 to up to 5 to 20. And once that got out, it took about 6 months, some of them 8 months. They're cleaned up, they're running. The plunger lifts, when they put them in, the production went down because you don't put plunger lifts in a depleted reservoir. And they got stuck in the bottom, had to get water lined out. I shouldn't have to pay for that. That was just a dumb move on his engineer. And they had to pull him. The first half year, Mr. Humberto screwed everything up he could.
So you're saying production volumes were relatively
Flat
flat
after they,
all the way through, and
after they-
prices were what you say. So you went through this with the division, though. Okay, so what's your response to that? Because obviously, just more fees, more costs were taken out by ARB, netting it down to a lower number. But were they legitimate? And that's your question,
No, they weren't, because we have the Lone Mountain Marathon operating agreement, and the overhead in it is $300 a month.
Mm-hmm.
When you go from $300 to $1,800 to $2,000 a month, there's something wrong. And the first Lone Mountain operating agreement has a clause in there that keeps you hold on stripper wells. So if it isn't making money because of the price, they can lower it down to $50. But they want to keep the working interest owners whole. That was why the agreement was made, because we knew when we bought it, we were buying stripper wells. And we knew we had to keep the cost down. And Mr. Routson was agreeable to do that.
Yeah, and I'm not sure how much we can get into the weeds of it, but
Yeah, this is,
But-
let's maybe hear from the division.
Yeah, thank you. So the division's here today because Mr. Fees, LLC, which is Walter Fees and Son Oil and Gas LLC, filed a request for agency action due to non-payment of production, as they're allowed to do under 40-6-9. And as part of that, the division was asked to investigate and negotiate with, I'll keep saying Mr. Fees, but that's not who the actual party is, but Mr. Fees and ARB. And as part of that, the division carried out a 60-day investigation. I have Ms. Wallace with me today, and she can give you a summary of what she did and what was found there.
My papers ready.
Ms. Wallace?
Yeah.
I need
Do
to
we
swear
n-
you in.
Okay, do you
Be
need to?
witness.
Yeah.
Please,
So go-
please raise your right hand. Do you swear that what you're about to present to the board is the truth, whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Good morning, board. My name's Brittany Wallace, and I'm the auditor for the Division of Oil, Gas, and Mining. I conducted the investigation and mediation in the matter of Walter S. Fees Jr. and Sons Oil and Gas regarding their petition against ARB Energy Utah. Over the 60-day investigation, I facilitated a mediation session and multiple follow-up discussions with both parties. As a result, ARB issued outstanding payments and provided the petitioner with various contracts, agreements, and production and disposition documents. The investigation identified $8,824.55 in additional revenue owed to the petitioner. We were able to get $17,928.89 in fees credited back to Mr. Fees. However, he did have a balance of $17,813 owed to ARB per their jibs, resulting in a net amount of $8,940.43 due to the petitioner through July 2025 production. ARB has issued a payment of $7,559.87 towards this amount. There are, however, additional outstanding items the petitioner is requesting from ARB, and $53,666.91 in disputed charges could not be resolved as the disagreement centers on differing interpretations of their joint operating agreement. And I just want to note, I just did a quick review of his 1099s and the estimation. So if you take the $53,666.91 of fees he's disputing, adding it into $8,940.43, you get $62,607.34. And Mr. Fees wants, or believe he's due about the $63,000. It's only about $555.20 difference. So it really just kind of aligns with the investigation that there's a disagreement in billing, and their joint operating agreement calls out how they can be billed. And so then at that point, I'll hand it back to Mr.
Sure, and I'll allow you to ask Ms. Wells any questions if you want to, but essentially, the division did their role, and there remains a disputed amount in fees and expenses. Those fees and expenses are governed by a joint operating agreement. If the parties cannot agree on how those should be paid or the dispute, the division can't offer legal advice or legal opinions on who's right or who's wrong in that matter. So the division has gone as far as they can in this matter.
So, Mr. Fees, the division has suggested that your dispute with ARB be resolved perhaps in district court and not here. Do you agree with this?
That'd be fine.
Let's move to ARB for a presentation.
Thank you. As you've heard, the division investigated here. ARB was cooperative, acted in good faith to try to resolve this. There is a genuine dispute. ARB has calculated its owed payments from Walter Fees, the LLC, and the LLC is not satisfied with that and is not satisfied with the division's conclusions and recommendations. But ARB is following the division recommendations. ARB, as noted, already paid $7,500 towards that approximately. It's just a rough number, but that was due to an initial report that was provided by the auditor. So there's $1,300-ish outstanding that ARB intends to pay immediately. That first check wasn't cashed yet, but that's the intent. ARB doesn't object to that adjustment. As you heard, about 70, as part of the negotiation and mediation, ARB actually credited back 17,000-ish that it believes that are legitimate, but credited that back to try to resolve this. But there is 70,000 that are owed based on the joint interest billing. If needed, if necessary, I can get into more detail. I do have an ARB accounting executive ready to appear if necessary, but from our perspective, the dispute here is contractual in nature. One of the issues is we believe the LLC is not taking into account the fact that the relevant agreements and JOAs all have, from everything I've seen so far, all have escalator provisions in them. And so COPUS comes out with recommendations, and there is an escalation that goes along with that. And so to us, it is contractual in nature. You've heard Mr. Fees say that he doesn't find it inappropriate for the court to resolve that if the parties can't reach a resolution, which we very much would like to do. And we understand that Ms. Wallace was able to reconcile the ARB volumes reported and paid, so we still don't understand exactly why the LLC is thinking that it was off, and I would just say that suspicion and historical averages and those kinds of things are not enough when you actually get into the facts, and the division has done its job in doing that, and ARB has fully cooperated. As far as pricing, ARB goes with what the purchaser has sent us. So Walter Fees has the burden here. Suspicion's not enough. Pointing to the other ARB disputes that might be out there is not enough. Historical averages don't really show anything. They really aren't probative or relevant. And so we're following the division recommendations, and in our view, that should end the matter and for now, and we would ask that it be dismissed on that basis.
Do you have any sort of explanation why the revenues went from 10,000 to 1 overnight? Was it production?
I don't, and that's the first that I've heard that today. But again, the division investigated what has been claimed in this agency action, and my understanding is that hasn't come into it. So to me, it sounds like a red herring, but I'm not familiar with it, so I don't know.
Would you agree that this dispute should be settled by a district court?
Yeah, I think that would be appropriate. That's why I would ask that with ARB's commitment to follow the current recommendation, that the remaining issues, if they can't be resolved, which we're still willing to negotiate and try to resolve, that those be left to the district court, and that this particular action be dismissed without prejudice to future issues.
Division, do you have any final thoughts on this?
You asked the question of why revenue dropped. Our understanding is because expenses went up. And unless we can identify, or the parties can identify, why an expense should or should not apply, there's really nothing more we can do there.
Thank you.
Just a quick comment.
Mr. Moon.
Yeah, so, looking back at Lone Mountain, the expense to gross income ratio is about 30%. I'm just glancing through it. ARB's expense to gross income ratio is like 80-90%. So totally, sympathize with your concerns. Their expenses went way up. But when it comes down to it, disputing those, that's the JOA, and that's a place that the district court can, decide and decipher, the contractual agreements there. But yeah, the expenses went up, the income, was up and down. But I guess what we've done all we can do. The division's done all they could do based on.
Yeah, my only comment was when he talked about the joint operating agreements. ARB has not followed them. Loken, his other company, have not followed any operating agreements. He was voted out of the Lone Mountain properties, and he refused to move. He isn't paying the overrides on time. He's not paying the working interest on time. He's absolutely not following them. So yeah, I think that's where it's going to end up, and I think Dr. Pachetti is taking him to district court to remove him.
Do we have any other comments from the board?
I have one more comment.
Okay.
And this is the question I have. I've watched these meetings, so why isn't Humberto Servant here representing himself? Why isn't Dave Bullen, Chief Investment Officer, here? Joseph Frost walked out of you in the middle of a meeting. Dave Porter, he's their Chief Regulatory Officer, and he's not here. Daniel Benedict was the ones, and Reese Orens were the ones that screwed up the wells. Why aren't they here? Diane Nelson, Director of Independent Relationship, isn't here. Cliff Klinger, Land Advisor. Dave Patterson, he charged ARB $137,000 to do a geological study that was already done by Lone Mountain. Larry Hartman, Chief Financial Officer, you would think that he could answer all these questions. So that's my last comment.
Do you have any response, Mr. Donaldson?
Not specifically to that, but Mr. Moon noted the increase in expenses. There was one item that the LLC brought up, and to me it's kind of an example. In responding to ARB's objection, he said, "I will not pay for the Surgitech treatment and plunger lifts." Basically saying, I'm not going to pay for it because it didn't yield additional gas. And that's really not the standard, just because it didn't work. And so that's just one example of an expense that, has led to a different net number. But these expenses are real. We've submitted all the information on them. They are what they are, and everyone is being treated the same with them. And so whatever ARB's net is also what it is. And so we're all in it together, and we do think if this dispute can't be resolved, the appropriate place to do that is in court.
You do not put Surgitech down 26 wells at once. You try it on 1 or 2 wells to see if it works. You do not put 15 plunger lifts at once.
Thank you, Mr. Fees. You need to address us.
Okay, sorry about that. And your amount of increase overhead compared to what Routson was doing at the last month, the difference between him and yours at the end is $1.3 million. You've increased revenues. We're not in this together. You're making money off the overhead. I'm losing money, but you're making money off the overhead, and that's the way you're working things.
I'd like to thank everyone for the comments. Board, do you have any further comments? I believe we need to deliberate on this for just a minute. Seeing no other comments, we're going to deliberate for a few minutes. We'll be back with a decision shortly. We are back on the record. We have deliberated, and I believe we have a motion.
I move that under Utah Code 40-6-9 6B, that the information gathered during the investigation and negotiation shall be given to the petitioner, who may then seek remedy in a court of competent jurisdiction. The board will not set a hearing on this matter, and this concludes the matter before the board.
Do I hear a second? I second. It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed?
I abstain.
We have 6 approvals, 1 abstention. Patrick James. And I think we'll do a roll call here, starting here. Mr. Moon? Aye. Ms. Sierra? Aye. I'm an aye.
Aye.
Abstain.
Aye.
Thank you. This matter is concluded. Thank you for your presentations. Thank you. I'll just accept that you're glad this is over. Oops. Well, hello there. And we are.
So matter
4, 5. Yeah.
Finley Resort.
And this is 470. 22. Mr. McDonald, will you let me know when you're set? Thanks.
Morning, Gordon.
I'm just waiting for the people to come up who need to be sworn in. We need faces here.
Will our online witnesses that are here for this matter turn your cameras on so we can swear you in when the time comes?
Thank you. Okay, we're moving on to docket number 2025-056, cause number 470-22. In the matter of the request for agency action of Finley Resources, Inc. for an order amending the board's order entered in cause number 470-05 to 1, modify and enlarge the stratigraphic definition of the spaced interval by 100 feet, 2, clarify interwell setbacks applicable to the long lateral horizontal well drilling units established thereunder, and 3, expand the allowable distance from either side of the common boundary line of the 2 long lateral horizontal well drilling units, comprising the drilling units for internal drilling unit boundary wells up to 330 feet, pertaining to sections 13 through 16, 21 through 27, 34 through 36, Township 4 South, Range 1 East, USM. Mr. McDonald.
Fred McDonald of Council with Lear and Lear on behalf of petitioner Finley Resources, Inc.
Division.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Back to you, Mr. McDonald.
Thank you, Madam Chair. With me today, appearing virtually to the board, pursuant to the board's order on November 20th and December 1st, and thank you, by the way, for that, are Ms. Jennifer Reed, the Vice President of Land. Jennifer, if you just wave. Mr. Justin Anderson, the lead geologist. Justin, would you wave, please? And Mr. Colin Strawn, the reservoir engineer. And I would ask that the Vice Chair swear them in at this time.
Please raise your right hand. Do you swear the evidence you're about to present to the board is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Yes.
Yes. Thank you.
Thank you. The resumes of all 3 witnesses were collectively submitted as Exhibit A as supplemented in this cause. If asked, each would confirm that the information recited in their respective resumes is true and correct. Ms. Reed will be a fact witness only. Messrs. Anderson and Strawn have previously been recognized by the board last September in cause number 470-20 as experts in geology and petroleum engineering, respectively. Based on their resumes and presuming the division has no objection, we ask that the board again recognize them as experts in those respective disciplines for purposes of this cause.
No objection by the division.
Board. No objections, please proceed.
Thank you, Madam Chair. I also just, is with existing practice, I'll be moving for admission of our exhibits at the end of our presentation in chief as a whole. Members of the board, today Finley seeks amendment of the board's previous order entered in cause number 470-05, which established overlapping 2-sectional stand-up drilling unit and boundary well drilling units for long lateral horizontal wells pertaining to sections 13 through 16, 21 through 27, and 34 through 36 of Township 4 South, Range 1 East in Uena County, which Finley refers to as its Leland Bench prospect. Finley first seeks to increase the upper interval of the spaced interval 100 feet for additional resource recovery and to account for potential drifting above the top of the long point member. Secondly, the 470-05 order failed to address setbacks between existing wells and newly drilled long lateral horizontal wells. Due to that omission, arguably the current setback from existing wells is 1,320 feet under Rule R-649-3-2. For the same reasons outlined in and consistent with the board's recent order entered in 470-20, Finley requests the elimination of such setbacks. Finally, Finley seeks expansion of the allowable distance from the common boundary line of the drilling unit boundary drilling units from 100 feet to 330 feet to allow for flexibility and for anti-collision purposes between stacked wells. This same relief was also granted by the board last September in Vernal in the 470-20 order. True and correct copies of the 470-05 and 470-20 orders and of Rule R-649-3-2 were collectively submitted as Exhibit B in this cause. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5 subparagraph 3B and 40-6-6. Notice was sent via regular mail to all the production interest owners and the requested drilling units and to the Bureau of Indian Affairs and the Vernal Office of the Bureau of Land Management, who serves as the technical advisor to the Bureau of Indian Affairs, because they are the governmental agencies having oil and gas jurisdiction over many of the lands. The mailings were sent to these parties at their last addresses disclosed by the relevant agency and Uena County Realty records. The record will also reflect that notice was duly published in the Salt Lake Tribune on November 9th and in the Uena Basin Standard in the Vernal Express on November 12th. On November 19th, the division filed a response indicating its non-opposition to the granting of Finley's request presuming Finley satisfies its burden of proof, which we will do today. No other objections or responses were received, and no other party has made an appearance here today. With that, I'll commence my examination of Ms. Reed. Ms. Reed, would you please state your name and business address for the record?
Yes, sir. Jennifer Reed. It's P.O. Box 2200, Fort Worth, Texas 76113.
And what is your current position with Finley, and how does it relate to the lands at issue today?
I'm the Vice President of Land. I assist with land-related issues pertaining to the lands at issue in this cause.
All right, for the record, would you please state the corporate and bonding status of Finley?
Yeah, Finley is a Texas corporation with its principal place of business in Fort Worth, Texas. It's duly qualified to conduct business in Utah and is fully bonded with all the relevant federal and state of Utah agencies.
I'm now going to show you what have been marked as exhibits C through F on the PowerPoint. Do you see these exhibits?
Yes, sir.
And were they prepared by Finley personnel with your review and input?
Yes, sir, they were.
Turning your attention now to Exhibit C, would you please explain to the board what this shows?
Sure. This is just a regional locator map that points out the lands at issue. Leland Bench, which is that red square there, it's approximately 8 miles southeast of the Mighton town site in Uinta County.
Now turning to Exhibit D, would you please explain to the board what this shows?
Sure. And this reflects the lands at issue. Order 470-05 established 2 sectional stand-up overlapping DSUs for long lateral horizontal wells and 4 sectional internal boundary well DSUs. So you can see that there.
And that would be the drilling unit boundary wells are sections 15, 16, 21, and 22, 14, 15, 22, and 23, 13, 14, 23, and 24, 27, 34, 26, and 35, and 25, 26, 35, and 36. Is that correct?
That is correct.
All right. Now turning your attention to Exhibit E, would you please explain to the board what this shows?
Sure. This plat reflects the mineral ownership of the Leland Bench area. The green area is tribal minerals, and then you'll see the white area there is fee-owned minerals. Finley is the majority working interest owner or the controlling working interest owner through designation as operator in all of these lands.
Now turning your attention to Exhibit F, please explain what this shows.
Sure. This shows the existing wells in the Leland Bench area. 100 are producing vertical wells, 2 are saltwater disposal wells. To date, no horizontal wells as authorized under 470-05 order have yet to be drilled.
All right, now I'm going to ask you to turn to the certificate of service. I believe you have a hard copy in front of you. Is that correct?
I do.
This was a pleading already on file in this matter that was prepared by my office. Do you recognize all the names and addresses that are shown on there, and who are those parties?
I do, and these are all of the production interest owners within the Leland Bench area. Those are shown on the exhibit there. And then we notified the governmental agencies having mineral jurisdiction. Those are also listed there.
All right, and how were those names and addresses compiled?
So we used our internal land records, including title opinions, division orders, and then a search of the BIA and Uinta County records prior to filing the RAA by Finley's, our land contracted services group.
All right, Madam Chair, that concludes my examination of Ms. Reed.
Just a couple questions. You indicated there's 102 existing wells, but none of them were drilled under the 47-05. And you also indicated that Finley is the majority working interest owner. So what is above the requested 470-05? Like, what are you? What are the wells targeting that are above the subject lands that we're looking at today?
I would confer with counsel on this, but I believe we're going to get into that with our engineering and geology review.
Okay, that's fine. But so the shallower wells, you are also the majority working interest owner in those as well then?
Yes, sir, and the operator.
Okay, thank you. That's good enough. No further questions.
Board, do you have any questions for this witness? Seeing none, please proceed.
Thank you, Madam Chair. With that, I'll conduct my examination of Mr. Anderson. Mr. Anderson, would you please state your name and business address for the record?
Yes, my name is Justin Anderson. My business address is P.O. Box 2200, Fort Worth, Texas 76113.
And what is your current position with Finley, and how does it relate to the lands at issue today?
I am the lead geologist here at Finley, including all duties as related to these lands here in Leland Bench.
And I'm now going to show you what have been marked as exhibits G and H for purposes of this cause. Do you recognize these exhibits?
I do.
Were they prepared by you or Finley personnel with your review and input?
Yes.
Turning your attention now to Exhibit G, would you please explain to the board what this shows and its significance to today's hearing?
Sure. So there's two things shown on this map. The left side is just the locator map, which outlines the application lands which we internally call Leland Bench. The star there is the location of the type well in section 21. And that type well is shown on the right. What you're seeing here is sort of a zoomed in view of the lowermost portion of the Lower Green River and Upper Wasatch, which is what we're calling the horizontal development portion of the Lower Green River and Wasatch. Outlined in red there, you can see the additional 100 feet that we are requesting to be added, which is the 100 feet immediately above the Long Point submember, which will allow us to effectively drill the Long Point without drifting out of the approved zone.
And is there also possible resource recovery in that additional 100 feet?
Yes, there is.
All right. Now turning your attention to Exhibit H, would you please explain what it shows and its significance to today's hearing?
Sure. So this is a very similar exhibit. Application lands on the left with the cross section going from west to east. This cross section includes the type well. It is the second well from the left. And this just shows the entirety of the Lower Green River as well as the Upper Wasatch. It shows the continuity of the reservoirs across Leland Bench through the Lower Green River, including the zone that we are extending above the Long Point.
Okay, is it your expert opinion then that the continuity and uniformity of the additional 100 feet above the Long Point member justifies its inclusion as part of the space formations and will result in additional resource recovery and to account for drifting?
Yes.
Right. Madam Chair, that concludes my examination. Mr. Anderson?
Division.
Just kind of reiterating what I was trying to ask the previous witness. We're asking for that extra 100 feet. There's already wells existing above the requested depths. Are you aware of any wells that would be impacted that currently exist by this 100 feet request?
No, there are, as you, we kind of, we'll get into a little bit later, but there are vertical wells that exist, that have existing perfs in the Lower Green River, including the area that we're talking about today. But we do not expect those vertical wells to be impacted by this development.
All right. Also, with the board's permission, we just have a comment that Megan Crocker would like to make.
Sure.
Oh, yeah. Can you just make sure in the future?
Could you introduce yourself, Megan?
Oh, Megan Crocker, Engineering Geoscience Manager. Could you make sure to include APIs on all your cross sections to ensure we can identify those for the future.
Sure, absolutely. Sorry about that.
No further questions from the division. Thank you.
Board, do you have questions? Mr. Moon?
This might be more for Fred, just for my education. So I don't recall ever modifying or enlarging the stratigraphic definition of the spaced interval. Like, normally it's just a big wide swath, and normally we think, you know, we're looking down on it. It's just everything. I mean, is there ever any case that we have different spacing at different depths?
The 47005 order is different because it stopped at the Long Point member, which is basically around the top of the Castle Peak.
But then it was just unspaced then.
Right above it. And so
Okay.
now they're adding the additional 100 feet.
Okay,
to make
why
sure
not
that
add the
part-
rest of it to the surface?
You can ask Mr. Anderson
Yeah.
that question.
But I'm just kind of wondering, you know, do we ever space it differently at different depths? And, you know, why not? Why do we only space like this area?
Justin, do you want to
Yeah,
answer?
I don't have a good answer for that. But we could have asked for that. We're sort of just asking for what our immediate focus is for horizontal development.
Because I guess in theory, in other states, maybe you have that different spacing units for different depths based on the, you know,
the geology. of it.
geology.
Right. And it would be based on, normally it would be based on whatever the drainage area
Right.
the wells would
Right,
be.
which could be different. But,
Right, based
but-
on the formations and the reservoir characteristics. But I think what you're thinking is, we're used to in the Iona Basin doing the entire
Yeah.
Lower Green River Wasatch.
Yeah.
And this one's a little bit different.
Okay. Yeah, and we're just only adding 100 feet. I was just curious, you know, why not make it 500 feet just in case, but, you know. Okay.
Understood.
Thank you.
Any further questions? Seeing none, please proceed.
Thank you, Madam Chair. With that, I'll commence my examination. Mr. Strom. Mr. Strom, would you please state your name and business address for the record?
Colin Strawn, P.O. Box 2200, Fort Worth, Texas 76113.
And what is your current position with Finley, and how does it relate to the lands at issue today?
I'm the operations and reservoir engineer for our Utah asset.
And that includes these lands, is that correct?
Yes.
All right, turning your attention now to exhibits I, J, K, and L. Do you recognize these exhibits?
Yes.
And were they prepared by you or Finley personnel with your review and input?
Yes.
All right, can you confirm for the record that you agree with Mr. Anderson's assessment that the additional 100 feet in the stratigraphic definition will help account for potential drifting?
Yes.
All right, now turning your attention to Exhibit I. This is a two-page exhibit. Starting with the page 1, would you please explain what this shows?
Yes, on I1 there, that's the currently approved layout. It considers boundary wells to be within 100 feet of either side of the DSU boundary lines. And so when then a 330-foot interwell setback is observed, that leaves us with these dead zones on either side with no drilling allowed. That would be shown by the yellow strips there.
All right, and on the second page?
Yes, if we go to this next slide, you can see what we're requesting. And so this modified layout for DSU boundary wells would allow us to drill anywhere within this 330 foot of the boundary line. And so any wells within that white strip there in the middle would be considered boundary wells. So that additional space would just give us much more flexibility for anti-collision.
All right, I'm going to refer you back to Exhibit F. And this is, as you recall, this is the exhibit that shows the existing wells. How will these existing wells impact the location of long lateral horizontal wells?
Well, it's going to be, there are, as you can see, many wells, 100 wells already there. So we just need some flexibility in order to drill straight wells. And so it's going to be, in some areas, it's going to be more important than others, but you can see on the, on the section 13 and 16 that are where they're developed at 40 acres. We're just going to need as much flexibility as we can get to drill close by those existing vertical wells.
All right, in that regard, let's turn to Exhibit J. Let's start with the first page, and please explain what this shows.
Yeah, so I'm about to show 3 examples of vertical wells whose production has greatly benefited from an offset horizontal frac. And so the wells that I'm about to show are just noted by the blue stars there on this map.
All right, let's start with J2.
So, yeah, on J2, this was just a flat 8-barrel-a-day well that was then hit by a nearby offset horizontal frac, got up to 50 barrels a day temporarily before declining and flattening out just under 20 barrels a day.
All right, J3.
Yeah, this one's a little less pronounced, but it was a flat, about 7-barrel-a-day well that got up to about 30 barrels a day temporarily before leveling out at 12 barrels a day or so. So that greatly impacted, increased the life of that well.
And finally, J4.
Yeah, so this was already a decent well of about 25 barrels a day, but on a fairly steep decline. It got hit by an offset horizontal frac and got up to about 45 barrels a day with an even shallower decline than before. And I should also mention, just to set the table a little bit, that all of these are vertical wells that are really completed, in a really common way through the basin with 1,500 to 2,000 feet of gross interval from top to bottom. So we're talking about hundreds of perforations in each of these wells.
All right, now turning your attention to Exhibit K, please explain what this shows and its significance to today's hearing.
Yeah, this is just a summary that I put together of all the existing vertical wells that fall within these DSUs. You can see the remaining reserves for combined in each DSU for the existing vertical wells. The main point here to bring up is just that if you add up all of the remaining reserves in all of these DSUs, they add up to about 1.4 million barrels. But to put that in perspective, if we fully developed when we fully developed these DSUs in only one target interval, say just the Uteland Butte, the reserves that we expect to add is at least 15 times that. And so then you could multiply that even farther for additional zones. And you can also see my note on the left there that that the average producing vertical well in this area makes just over 5 barrels a day currently. So we're getting into marginal well territory.
And turning your attention to Exhibit L, would you please explain what this shows?
Yeah, so this just takes into account what I just said on the previous slide. The average vertical well makes just over 5 barrels a day in this area. So with the economic assumptions that are listed on that slide, the average well on 40 acres has a present value of around $180,000. And so as it shows there on the bottom, if you divide that 40 acres from a single vertical well into 1280, a 1,280 acre unit, that would in theory result in just over 3% ownership. And so 3.125% of each horizontal well would have a value of at least $150,000. So or 600,000 for 4 wells. And so the main idea here is just to illustrate that the value of developing this horizontally is much more proportionately much more valuable than these existing vertical wells.
All right, now I'm going to direct you to Exhibit M. This is not on a PowerPoint. This is an official business record of Findlay, is that correct?
Yes, it's not showing up on the screen. Oh, you
No,
already said
yeah,
that.
it-
But
it
yes,
won't be in.
I had it.
Okay,
Yes, that's right. It is.
okay.
It's the
and-
same one that we showed in September, right?
Right, correct. And would you
Yes,
please
sir.
explain what that is and its significance too?
Yeah, it's just it shows another field in West Texas that we have ownership in, that we were just using as an example of other areas where the removal of interwell setbacks is allowed, and which is what we're requesting here.
I'm pointing out to the board, if you look at Rule 2, the second sentence of it, that's where it says that there's no interwell setbacks in that field. And you will recall that this is the same exhibit that was submitted as part of the 470-20 order that you had in Vernal. All right, Mr. Strawn, is it your expert opinion that the 330-foot buffer for drilling unit boundary well DSUs is needed for anti-collision purposes?
Yes.
Is it also your expert opinion that the elimination of interwell setbacks between existing wells and long lateral horizontal wells may in general benefit rather than harm correlative rights of the owner in those existing wells, and is also consistent with practices in other basins and is previously authorized by the board in the 470-20 order?
Yes.
Finally, is it your expert opinion that the requested relief will allow the greater recovery of natural resources with associated greater economic benefit and with no or minimal adverse impact on correlative rights?
Yes.
All right, Madam Chair, that concludes my examination. Mr. Strawn?
Thank you. Division?
Just one question. Since you are requesting the have no interwell setbacks, you do show 3 examples where you do get benefit out of fracking those horizontal well or vertical wells. Do you have instances where it just does nothing or sometimes negatively impacts wells? Is it, I know you just have 3, but it's like, what about the rest of the wells? How do they get impacted?
Yeah, a lot of times you'll never see anything, never notice anything. We've seen, I know of one example where one well sanded up and the operator had to clean it out in order to get production back. But like I mentioned, the average well around here being 5 barrels a day, we're really optimistic and excited to potentially substantially increase production on these, and we think that greatly outweighs the risk.
Thank you. Nothing further from the division.
Board, do you have any questions for this witness?
Yeah, quick question. So you've talked about the benefit to the nearby vertical wells, and that's great that happens. Wouldn't there be some detriment to that horizontal well if some of that energy is going into the vertical wells? There would be some reduction. I don't know if there's any way to measure that, but have you thought about that?
Sure, we've thought about it, and it's just hard to quantify, really. These vertical wells are, like I said, have so many perforated intervals that any given perforation on even a good well, any one perforation may only be making a small percentage of a barrel a day, even on a good well, and then you just add all those up and you get to a 10 or 20 barrel a day well. But yeah, we think that in general these are the vertical wells are very understimulated, just because it's hard to get a good frac on a vertical well when you're stacking up a bunch of different lithologies. And so I think it's pretty clear that the best way to produce the resource overall, is by adding all these horizontals.
Thank you.
Board, do you have any other questions? Back to you, Mr. McDonald.
Thank you, Madam Chair. With that concludes our presentation in chief. At this time, I would move for admission of Exhibits A through M inclusive.
Any objections from the division?
No objections.
From the board? So admitted.
Thank you. With that, I'll reserve my closing comments after the division's presentation.
Thank you.
Thank you. As indicated in our response, we previously reviewed the RAA and the division reviewed the exhibits. And based on the testimony here today, the division has no opposition to the modification of Order 470-05.
Thank you. Board, any closing comments? Mr. McDonald.
Thank you, Madam Chair. Again, with that statement by the division, we believe that we've met our burden of proof. We've met the statutory and regulatory requirements for the granting of the request as submitted, and we would ask that the board grant it as requested.
Thank you. Board, are we ready for a motion, or do we need to deliberate? I believe we're ready. Could I get a motion?
Yeah, I move that we approve this request for agency action.
Second?
I'll second.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. McDonald.
I
Would
will-
you prepare the order?
Yes,
for
I
us?
will, and I'll make sure the council for the board and the division have it before submittal.
Thank you. Thank you. Are you doing the next one also?
Yes, ma'am. Okay, so Clint Cook.
Right.
and,
Number
Sarah
7.
Smaltz, and then Brett Kovac.
Yeah. So we don't even,
Sarah second,
because
Clint,
it's gone.
Sarah, Brett.
So this is the last.
Ready when you are, Madam Chair.
Moving on to the next docket. Docket number 2025-057, cause number 130-44, in the matter of the request for agency action of 4 Point Resources, LLC, for an order establishing overlapping laydown 1,920 acre drilling units for extra long lateral horizontal wells for the production of oil, gas, and hydrocarbons from the lower Green River Wasatch formations, comprised of sections 1 through 3, 4 through 6, all in 3 South, 3 West USM, with certain caveats relating to existing wells thereon. Mr. McDonald.
Thank you, Madam Chair. Fred McDonald of Council with Lear and Lear on behalf of petitioner 4 Point Resources.
Division.
Gary White on behalf of the Division of Oil, Gas, and Mining, and I'm here with division experts Peter Pankey and Andrew Hoyer.
Thank you. Mr. McDonald.
Thank you, Madam Chair. With me today, appearing virtually pursuant to the board's November 20th order, are Mr. Clint Cook, Senior Landman, Ms. Sarah Smaltz, the Senior Geologic Advisor, and Mr. Brett Kovac, the Senior Reservoir Engineer, and I would ask that the Vice Chair swear them in at this time.
Please raise your right hand. Do you swear the evidence you're about to present to the board is the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do. I do.
Thank you.
The resumes of all 3 witnesses were collectively submitted as Exhibit A. If separately asked, the witnesses would confirm that the information shown on those resumes is true and correct. Mr. Cook will be a fact witness only in this matter. Ms. Smaltz and Mr. Kovac has been previously recognized by the board in several matters as experts in geology and petroleum engineering respectively. Based on the resumes, and again, presuming that the division has no objection, we again request that the board recognize them as experts in those particular disciplines for purposes of this cause.
Any objections?
No objection. Thank you.
Any division or board? They are accepted.
Thank you. And again, I will be moving for admission of our exhibits at the end, as collectively at the end of our presentation in chief. Members of the board, 4 Point is before you today seeking establishment of 2 overlapping 3-sectional laydown drilling units for extra long lateral, or I will refer to them as 15,000 or 15K wells development in the lower Green River Wasatch formations comprised of sections 1 through 3 and sections 4 through 6 respectively of Township 3 South, Range 3 West in Duchesne County. The board previously established these lands as 3 two-sectional laydown units pursuant to its orders and cause numbers 130-24 and in 130-28. True and correct copies of those 2 orders were submitted as part of Exhibit B in this cause. These orders previously modified prior orders to reorient the 2-sectional drilling units from stand-up to laydown. Pursuant to those prior orders, Newfield, 4 Point's predecessor, drilled 2 stand-up 10,000 foot wells, the Parank well in former sections 3 through 10 drilling unit, and the Ute Tribal well in former sections 6 and 7 drilling unit. The 130-24 and 130-28 orders expressly provide that allocation from those 2 wells is to remain on the stand-up drilling unit basis. However, no laydown 10,000 foot wells have been drilled since the 130-24 and 130-28 orders were entered. As the board is aware, the trend in the basin is now to drill 15,000 foot wells. 4 Point desires 15,000 foot well development on these particular lands, with authorization to drill up to 20 such wells and maintaining 100-foot heel-toe setbacks and 560-foot perpendicular setbacks. However, it does not desire to disrupt existing rights to production currently established under the 130-24 and 130-28 orders, and therefore seeks that the requested drilling units overlap and not result in any conversion. Even though these will be overlapping drilling units, 4 Point is requesting no inner well setbacks between the existing wells and newly drilled 15,000 foot wells. As the testimony will show, owners of the correlative rights in those existing wells actually benefit from new 10,000 or 15,000 foot wells by uptick in production and ultimate economic recovery of resource. Furthermore, no interwell setbacks is the trend in the Permian and Eagle Ford basins, and in cause number 470-20 last September, and as you just heard in the last matter, the board recognized that elimination of the interwell setbacks does not adversely impact adjacent existing wells. A true and correct copy of the 470-20 order was submitted as the remainder of Exhibit B in this cause. Since Indian mineral lands are involved, new communitization agreements are required, and the agencies, whether under federal guidelines or by practice, require the spacing order of the board for such communitization agreements to be approved. This is another reason why 4 Point is before you today. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested 3-sectional drilling units and to the Ute Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, and Vernal BLM due to the Indian ownership, also to the School and Institutional Trust lands and the Division of Forestry, Fire, and State lands due to some state ownership. The mailings were meant to these parties at the last addresses disclosed by the relevant agency records and the Duchesne County Realty records. In addition, notice of the filing of the request in this hearing was also duly published in the Salt Lake Tribune on November 9th and in the Uinta Basin Standard on November 12th. On November 19th, the division filed a response expressing no opposition to the request, presuming that 4 Point meets its burden of proof today, which it will. No other objections or responses to the request were timely filed, and no other party has made an appearance here today. With that, I'll commence my examination of Mr. Cook. Mr. Cook, please state your name and business address for the record.
Yes, Clint Cook, 4 Point Resources, LLC, 100 St. Paul Street, Denver, Colorado, 80206.
And what's your current position with 4 Point, and how does it relate to the lands at issue?
Senior landman overseeing the DSUs at issue here.
Would you please state for the record 4 Point's corporate and bonding status?
Yes, 4 Point is a Delaware limited liability company with its principal place of business in Denver, Colorado. It is the successor by assignment to Ovinev USA Inc., successor by name change, and merger to Newfield Production Company. 4 Point is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all relevant state of Utah agencies.
All right, I'm going to show you what have been marked as Exhibits C through I. Do you see those on the PowerPoint?
Yes.
All right. Do you recognize those exhibits?
Yes,
And were they prepared by you or 4 Point personnel with your review and input?
they were.
Turning your attention to Exhibit C, would you please explain to the board what this shows?
Yes, this is a regional locator plat showing the DSUs at issue here. The DSUs are located approximately a half-mile north of the Arcadia community, 1 mile south of the Upalco community, and roughly 6 miles northwest of Mighton Town site.
All right, turning your attention now to Exhibit D. This is a 2-page exhibit, starting with page 1. Please explain what this shows.
Yes, this shows the 3 existing DSUs as in their current 2-mile state, excuse me, 2-section state under orders 130-24 and 130-28.
And now on page 2.
This reflects the requested 3-sectional DSUs. The red area is referred to as the Gilbert DSU, and the blue, the Lusty DSU.
All right, now turning your attention to Exhibit E, please explain what this shows.
Exhibit E is a mineral ownership type plat. All of the green, both dark and light green, is Indian minerals, yellow is fee, and then orange shows state minerals.
And that's Sitlin lands in Section 1 and UDOT Forestry Fire and State lands in Section 4. Is that correct?
Correct. Yes.
All right. Have you had any experience, or what are the representations made about when you have Indian minerals and approval of communization agreements?
Yes. So based on our experience and understanding, when you have Indian minerals involved, a spacing order not only facilitates but is required by both the BLM and BIA for a conforming communitization agreement, whether by their guidelines or just actual agency practice.
Now turning your attention to Exhibit F, please explain what this exhibit represents.
Exhibit F shows you the working interest in the 3 existing DSUs, demonstrating that 4 Point has a very strong majority interest in each of the DSUs.
Now turning to Exhibit G, please explain what this shows.
Exhibit G is a plat showing the existing wells on the DSUs. Of note here would be the P-rank well in sections 3 and 10, and the Ute tribal well in sections 6 and 7.
And those are long lateral wells drilled on the prior orders, is that correct?
That's correct, yes.
And they were on a stand-up basis?
Yes.
All right, now turning your attention to Exhibit H, please go through this exhibit with the board.
So Exhibit H shows the allocation for all the existing wells that you just saw on the previous plat, and demonstrates that their production allocation will remain the same.
Under the 130-24 and 130-28 orders?
Yes.
Okay, and with that, you're asking for an overlap on these 3 sectional drilling units, correct?
Yes, these would be overlap, and consequently, there would be no conversion effect on these existing wells.
Okay, finally, turning your attention to Exhibit I, would you please explain what this shows?
I reflects the notice area for this RAA. It also includes it includes all production interest owners within the green area on this plat. And I would note that it includes sections 7 and 10 on the south end due to the requested elimination of setbacks from the P-rank and Ute tribal wells, production from which is partially allocated to those sections.
All right, now I'm going to direct you to the certificate and supplemental certificate of service. You should have hard copies in front of you. These
Yes.
are pleadings already on file that were prepared by my office. Can you confirm that those certificates identified the persons and their addresses shown on Exhibit I?
Yes, I can.
And that also includes the agencies that have mineral jurisdictions, such as the BIA and the BLM and SITLA and Forestry Fire?
Yes, they do.
Okay, how are those parties identified in the addresses?
So the parties and addresses were compiled from 4 points, internal land records, which include title opinions, as well as a search of the BIA, SITLA, DFFSL, and Duchesne County records prior to filing the RAA. And this research was done by Lone Wolf Energy, Inc., who is 4 points contracted land services company.
Right, and just for the board's knowledge, again, these were sent regular mail, so there's no Exhibit Z, which would be the certified mailing receipts on this one. With that concludes my examination of Mr. Cook.
Division, do you have questions for this witness?
No questions, thank you.
Board, do you have questions for this witness?
Yes.
Mr. Walker.
And in section 5, you've got a line that goes about halfway through that section. What is that?
Yes. In section 4, is this the
no,
mineral?
section. Well, okay, I'm sorry. In the prior map in section 5, it has a unusual line.
Oh, I'm sorry, on
Wait.
Exhibit I?
Right there, yeah.
Oh. The black line down the middle there would indicate the line between the two new DSUs. Is that what you're referring to?
No, there's a blue line, Clint, in section 5. I believe it pertains to the U tribal. It's a short lateral horizontal well.
Okay, I got you. Sorry. Yes.
I mean, is that a directional well of some sort, or what is that?
That's a 1 mile horizontal well.
Okay, so it didn't take a traditional route then. Okay, gotcha.
Below that, there's a dotted line that goes all the way to the south border in section 5. Do you see that?
Oh.
Yeah.
Is that a proposed well, Clint? Or?
It may have been, and I'll say this map. So the notice area map is was done by more on the land level with Lone Wolf. I would say if you refer to Exhibit G, would be a more accurate indication of the existing wells as is.
Okay. Got it.
This follows the dotted line, but it doesn't show the squiggly line.
But that might have been a remnant as an like an old permit or something. Again, I would say Exhibit G is your accurate depiction of the existing wells in these DSUs.
Okay, that makes more sense to me. Thank you.
Yeah, and Exhibit I is just intended to show you the sectionals that were notified.
Okay, thank you.
Do we have any other board questions, Mr. Moon?
Yeah, just a quick question. Of all the rest of 3 South, 3 West right there, that's all 2 sectional spaced, and are they laydowns? Just curious why only the 6 top sections being spaced, versus continuing that on down.
I would defer to my colleagues on here on any, technical reasons for why that is. It might be that, some of the existing development, or it might be that, we want to start with this one and then make those decisions at a later point. But I would defer to Brett and Sarah on that question.
Okay.
Mr. Church.
So on the notification, you have notified only people within the sections, you have not notified offset owners to these sections. Is that correct?
With the exception of sections 7 and 10, that is correct.
Is that a change in practice? Normally we see offset owners notified of spacing.
Perhaps I could answer that, Mr. Church. Under the 130-24 and 130-28, there are already now laydowns, and there are 100-foot heel-toe setbacks, east-west boundary, and 560 the other way, and that's the same even with this, with it changing. So that's why the offset owners weren't needed to be notified. It's the same setbacks as currently exist.
All right, thank you.
Any further questions? Division, do you have any questions at this point?
No, thank you.
Back to you, Mr. McDonald.
Thank you. With that, I'll commence my examination of Ms. Schmaltz. Ms. Schmaltz, would you please state your name and business address for the record?
Yes, Sarah Schmaltz, 4 Point Resources LLC, 100 St. Paul Street, Suite 400, Denver, Colorado, 80206.
And what's your current position with 4 Point, and how does it relate to the lands at issue?
Yeah, I'm the Senior Geologic Advisor for 4 Point, overseeing the development and planning of the DSUs at issue here today.
All right, I'm now going to show you what have been marked as exhibits J, K, L, and M for purposes of this cause. They're shown on the PowerPoint. Do you recognize these exhibits?
Yes.
Were they prepared by you or 4 Point personnel with your review and input?
Yes.
All right, starting with Exhibit J, would you please explain what this shows and its significance to today's hearing?
Yes, this exhibit has a map highlighting the location of the two proposed DSUs in relation to the field type log, which is the Shell Brotherson 1-11B4, which has been used and recognized in numerous orders. On the left-hand side of the exhibit, you will see the stratigraphic interval highlighted, which is defined as the Lower Green River Wasatch Transitional Formations on the type log.
Now turning your attention to Exhibit K, again, please explain what it shows and its significance.
Yes, Exhibit K is displaying a type log located within the particular DSUs at issue today. This is the Lusty 14-2-3-3W, and it's highlighting the primary target intervals for 15K wells that will be proposed within these subject DSUs.
Now turning your attention to Exhibit L, would you please explain what this shows?
Yes, Exhibit L is a more regional west to east cross-section through the DSUs at issue, including both the field type log and the local type log from the previous two exhibits. This cross-section is reflecting the uniformity of the target formations across the two proposed 15K DSUs. And this is also highlighting that the Lower Green River to Wasatch transitional formations constitute one common source of supply in this area and is consistent with the board's designation of those formations as one pool throughout the Uinta Basin.
All right, and to Exhibit M, again, please explain what this shows and its significance, particularly with respect to Mr. Moon's question.
Yes, so Exhibit M is displaying the interpreted maximum horizontal stress direction in the area surrounding the DSUs at issue today. The wells observed with observed stress indicators are shown with black arrows, and the average maximum stress direction near these proposed DSUs is interpreted to be north 12 degrees west, which supports laydown drilling units. We're also showing on this map, designated with a star, the Ute Tribal 4-18-3-3WH, for which the PVT data was used for drainage calculations, and Mr. Kovac will address these data in the following exhibits. And to address the previous question that was asked of Mr. Cook, we're requesting the Gilbert and Lusty, which is on the north end of Township 3 South, 3 West, as 15K DSUs, but you will also see further, or it's not highlighted on this exhibit in exactly, we don't have all the approved DSUs shown here, but there are additional 15K DSUs that had already been approved through orders that our predecessor, Oventive, had requested, including DSUs such as the Wheeler, and I believe there's one named Ute Tribal, further south in Township 3 South, 3 West. So these are not the only 15K DSUs within this township.
All right, is it your expert opinion then that the uniformity and thickness make the lower Green River Wasatch an attractive target for 15,000-foot well drilling?
Yes.
Is it also your expert opinion that the fracture orientation supports a lay-down drilling unit?
Yes.
Finally, is it your expert opinion that the lower Green River Wasatch in this area constitutes one common source of supply?
Yes, sir.
Madam Chair, that concludes my examination. Ms. Smalls?
Thank you. Division?
No questions, thank you.
Board? Seeing none, back to you, Mr. McDonald.
Thank you. With that, I'll commence my examination. Mr. Kovac. Mr. Kovac, would you please state your name and business address for the record?
Yes, it's Brett Kovach, and business address is 100 St. Paul Street, Suite 400, Denver, Colorado 80206.
And what is your current position with 4 Point, and how does it relate to the lands at issue?
Yes, I'm a senior reservoir engineer overseeing the DSUs at issue.
All right, turn your attention now to exhibits N, O, P, and Q. Do you recognize these exhibits?
Yes, I do.
And were they prepared by you or 4 Point personnel with your review and input?
Yes, they were.
All right, turning your attention to exhibit N, would you please explain to the board what this shows and its significance to today's hearing?
Yeah, so exhibit N provides an illustration of the DSUs at issue. So that north 12 west fracture orientation there was shown directly on the map that Sarah presented in exhibit N. And we can see from this exhibit that our effective fracture half lengths for the Uland Butte wells are expected to be no more than 110 feet. And exhibit N also demonstrates that at these requested setbacks, we're preventing waste and maximizing natural resource recovery. And based on the drainage ellipse that is defined by the Hale and Evers methodology, which we'll walk through in exhibit O, we can also view here that correlative rights will not be adversely affected.
All right, turning your attention to exhibit O, please explain that again.
Yes, so exhibit O presents our drainage calculations using the Hale and Evers methodology, which is a method that the division and board have previously deemed accepted and that we've shown previously. As Sarah stated, the PVT parameters used in the analysis come from the Ute Tribal 418333WH, which is a well that's within the subject area shown. And on exhibit M, we can see that it lies just to the southwest of the DSUs at issue. So we can see that these calculations demonstrate that at year 5, there's no drainage of adjacent lands, and beyond that would be very minimal, if any, at 10 years and beyond.
All right, turning your attention now to exhibit P, please explain what this shows and its significance.
Yeah, so exhibit P outlines the general economic benefit of extending laterals, and these benefits are really consistent with what we've seen in other basins. So a couple things to point out here. So in this case, we can see that cost per foot is generally expected to go down by about 15%, while the per foot productivity of the wells remains essentially unchanged. So really what this results in is more resource recovered per dollar of capital invested, which, as you can imagine, makes the economics strongly favor 15,000-foot development, which is shown here in the table.
All right, under the 130-24 and 130-28 orders, 17 of the 2-mile wells was authorized, but now we're seeking up to 20. Can you kind of explain why?
Yeah, the addition of that is primarily for the optionality for the upper cube wells, which we're continually looking at delineating, and that would be the kind of additional wells.
All right, now turning your attention to exhibit Q, please explain what this shows and its significance.
Yep, so exhibit Q provides 2 very recent examples from DSUs that are just offset this, where modern development actually increased the production in the existing wells. So the Stanley case on the left, we observed an uplift of roughly 35 to 40 barrels per day. And then in the Elton Blackhair DSU on the right, the uplift was approximately 15 barrels per day.
So in other words, there was economic benefit to existing wells when you drilled a new horizontal well close by?
Yes.
All right. What other steps do you take, does 4 Point do when it's completing a long lateral horizontal well close to an existing well?
Yeah, so in addition for the potential for the production increases, there's a few other things that we do. So we take deliberate steps before we're drilling the well to ensure that they're protected during both drilling and completion. So prior to drilling, the drilling engineering team will conduct very detailed anti-collision analysis to make sure that they kind of know the zone of uncertainty and build a directional plan that really minimizes any collision risk. And then additionally, during the completion operations, we'll make sure to shut in the existing wells to kind of allow the pressure to build up And we'll also closely monitor the pressures throughout the operation to reduce any potential risk there.
All right, finally, I'm going to direct your attention to Exhibit R. It's not on a PowerPoint. Again, this is the Texas Railroad Commission order in the Sprayberry field. Does 4 Point have a working interest ownership in that field as well?
Yes, 4 Point operates in this basin.
Okay, and again, that order is an official business record of 4 Point?
Yes.
All right, and so again, for the board's information, same rule as you've heard before and was used in the 470-20 order for the Sprayberry field, indicating that there's no well setbacks. All right, is it your expert opinion then that up to 20 wells may be required to recover additional resources in the Gilbert and Lusty drilling units which would otherwise be left in the ground?
Yes.
Is it also your expert opinion that the 100-foot heel toe and 560 perpendicular setbacks will not adversely affect the correlative rights of adjacent parties?
Yes.
Finally, is it your expert opinion that the elimination of the inner well setbacks between existing wells and newly drilled 15,000-foot wells in general benefits rather than harms the correlative rights of owners in those existing wells and is consistent with practices in other basins and other areas of the Uinta Basin?
Yes.
All right. With that, Madam Chair, that concludes my examination of Mr. Strawn, or Mr. Kovach, I'm sorry.
Thank you. Division, do you have questions?
No questions, thank you.
Board, do you have questions for this witness? Mr. Church.
Mr. Kovach, do you envision 4 Point's drilling any wells under the 2 well spacing in the future, or they all will be drilled on the 3 well or the 3 section spacing?
Yeah, I would imagine they'd all be drilled on the 3 sections.
Okay.
Any further questions? Seeing none, back to you, Mr. McDonald.
Thank you, Madam Chair. With that, that concludes our presentation in chief. I would move for admission of Exhibits A through R inclusive.
Division, do you have any?
No objection.
Board, do you have any objections? So admitted.
All right. With that, I'll reserve my time after the division makes its statement.
Thank you. Division.
Thank you, Madam Chair. The division has carefully reviewed the request for agency action, the exhibits, and upon hearing the presentation and evidence today, has no objection to granting the RAA.
Board, do you have any problems, questions, concerns? Seeing none, are we ready to make a decision, or do we need to deliberate? I think we're ready. Could I get a motion from someone?
You're looking at me, so I'll do it. I move that we approve this request for agency action.
Do I hear a second? Second. It's been moved and seconded. All in favor, please say aye.
Aye. Aye.
Any opposed? Motion carries. Thank you. Please prepare the order.
I will, Madam Chair. I'll make sure that the counsel for the division and the board have a copy of it before it's submitted for final.
Thank you.
And also thank you again to board members and the IT group for allowing the virtual appearances of the witnesses today. And on a personal note, I wish you all happy holidays and hope you're enjoyable and safe.
And same to you. Take care.
Thank you.
So it's 11:30. We are done with the formal items on our agenda for today, except for the bonding question. As I think you have all been informed, we're doing 15-minute, up to 15-minute presentations from each of, there are 10 groups that have requested time to speak. We're going to go ahead, if it's all right with everyone, and try to do the first 2 presentations. Julie, yes. Oh, sure. The 7th item on our schedule here. I don't have the. I got an old one. Okay, hang on.
Here it is right again.
Yeah. Thank you. All right. So the final item is docket number 2025-058, cause number 470-23. In the matter of the request for agency action of Uinta Wax Operating LLC for an order partially amending the board's order in cause numbers 139-84, 139-106, 139-135, 139-143, 139-154, and 139-157. 1, establishing 20 overlapping stand-up 640-acre drilling units, 8 overlapping stand-up 1,280-acre units, 4 unit boundary well drilling units, and 4 overlapping stand-up 3480 drilling unit boundary well drilling units, each for the production of oil, gas, and associated hydrocarbons from the Green River and Wasatch formations, and 2, setting uniform boundary and interval setbacks in sections 8 through 36, 2 South, 1 East, USM, and sections 13, 24, 25, and 36 in 2 South, 1 West, all in USM, Uinta County. Please note that this docket item has been withdrawn and will move to another meeting. Thank you. Now we'll go back to the bonding question. I think we'll try to get through the first 2 before lunch, because we do have a lot of people who'd like to speak. So, is everyone good? Do we need a break? I think we're good. Okay, the first person we have, and if you have it picked up, there's a list that's on sheets here by the door if you want to see where you are on the docket. The first one we have on the docket is Ricky Renko Browning. She is President, Uinta Petroleum Association.
Good almost afternoon, Madam Chair and the board. I do have a slide deck I'm going to try and queue up real quick.
We are going to try to time these, Ricky,
Okay.
to try to stick to that 15-minute schedule since we have so many presenters.
Understood. Let's see. All right, that looks like it's working. Are we good?
Sounds good.
Okay, well, again, for the record, Ricky Renko Browning, president of the Utah Petroleum Association. I want to start by thanking you all for your time. I know that we have all spent considerable time and effort, many, many hours on this bonding role, and I just want to say, high level, we are entirely supportive of the objective of the division and the board to try and find a measured and balanced solution that is protective of the state, protective of taxpayers, of the environment, but also protective of maintaining a industry-friendly environment that encourages continued investment and development into the state of Utah. That has been our objective all along. So I know that you're going to hear some high-level comments from other speakers today. My goal is really to stick very specifically to the role that is in front of us and speak about what are the changes that were recently made that we think are incredibly helpful and important in achieving that balance, and we would encourage you to keep as you consider the role in front of you today. And then a number of items that we still have concerns with, and speak through some of those, why we have those concerns and what we would suggest to see going forward. The other thing that I do want to note is that, as you all are aware, this rule is extremely complicated. Moving a definition, a calculation, or a concept has many domino effects. And so we are viewing all of these changes as a group together. And if we change some of these things, but maybe not other things in the rule, I do want to reserve the ability to come back with further comments and feedback, because that might change our position on some of these things. So to start with the items that we are extremely appreciative of, I want to thank the division staff and Director Thomas for working through these. The most important change that we've seen in the evolution of this rule is clarifying the application of how the 20%, 13%, and 18% of at-risk wells in Tier 1, 2, and 3 work in the calculation of the base blanket bond and the at-risk well supplement. We now think that the current draft has these percentages and the way that they are treated in the calculations appropriately dialed in, and that the current draft is sufficiently clear and agree with the methodology. We would ask that there not be any changes to how those percentages are included and utilized. Another major point that we've seen evolution in is protections to reduce the risk of double bonding, which is critically important. So the change in the definition of state well to protect against double bonding by including the specific language, quote, that is not otherwise subject to a performance bond with a federal, tribal, or other governmental agency having jurisdiction, end quote, is extremely important in protecting against double bonding that would unnecessarily tie up capital that could be used to otherwise meet the division's mission of promoting development of state resources, which includes promoting oil and gas exploration and development, while also, of course, striking that balance of protecting the public's health, safety, and environment. We think that's really important in striking that balance. Another point is making the bond applicable to only state wells where the division has authority, but allowing an operator's entire universe of wells in the state, whether those are state, federal, or tribal, to be used in qualifying the production qualifier for the base blanket bond and the at-risk well ratio. We think that that's a much better analogy of risk, but strikes that right balance. All right. So I wanted to speak as well to some of the challenges that we still have in our interpretation of the rule. And there's 6 main areas. Try and move through these really quickly with the timer in front of me. So the first is the treatment of temporarily abandoned and shut-in wells. We do not believe fundamentally that those should be treated as at-risk wells. Operators have many reasons why they may shut in or temporarily abandon wells that could have things to do with seasonality, it could have to do with pricing, or it could have to do with a thoughtful development of larger pads. We are no longer drilling pads with 1 or 2 wells on them, and the timing implications of bringing on multiple wells on large pads is very complicated. I know that you've heard concerns, and you're going to hear some from the other speakers today, that these wells are not high value for operators and that they pose a higher risk. We fundamentally disagree. They are high value, which is why operators are willing to go through the process to have these approved by the division under the existing R649-3-36 rules, which requires increased monitoring and record keeping. If they were not valuable, an operator would not have the incentive to undertake this additional effort and cost. And I'll give you just one illustrative example. If an operator, for example, were drilling a large 23 well pad, which is not out of the realm of reality of where we're currently going, let's say that they first go in and drill 3 wells. They bring those wells online, they need to assess production. That could take 6 to 12 months before they kind of have a full review of what that production looks like. If they were then to go back to drill and complete the remaining 20 wells, let's say it takes 9 days to drill each well and 10 days to complete each of those wells, and you're looking at an additional 20 wells, that's 380 days later before you can even bring those 3 first wells, which you would have had to have temporarily abandoned to safely drill and complete, back online. So we do have to be very thoughtful in how we stage wells and bring production online with these new larger pads, and sometimes that can take longer periods of time. So while in this case, this operator is very diligently developing this pad, they're investing significant sums to drill and complete, they are being penalized with significantly higher bonding requirements because they had to shut in those first 3 wells just in order to safely drill and complete the remainder of the pad. So there are plenty of circumstances where a shut-in or temporarily abandoned well does have very high value. We do not believe it should be considered at risk or that an operator's capital should be tied up and penalized because of it. And this is a really important distinction, just to be clear. Whenever we're talking about shut-in and temporarily abandoned wells, we're talking very specifically about division-approved SIs and TAs, where a sundry notice has been approved by the division already. Under the existing rules, the division has that discretion to determine if a well is or is not a risk to public health, safety, or the environment when they go through the process of approving or denying that notice. So if the division does in fact approve a SI or TA, it means that they have already determined that the well is in fact not a risk to public health, safety, or environment per the rule. So it then brings into question, why are we treating it as an at-risk well? So again, in the rule in front of you today, under the definitions of at-risk well, shut-in well, and temporarily abandoned well, the division has rejected the language that UPA has inserted that would have excluded division-approved shut-in and temporary abandoned wells. They also rejected UPA suggestions to remove division-approved shut-in and temporary abandoned wells from the blanket bond calculation. We would ask for your reconsideration there. The second issue that I want to talk about is the bond liability adjustments. We think that as the division is the ultimate authority on the bond amounts due, that they should also bear the responsibility to communicate the amount due and any changes to that amount due that arise to the operator. In the rule in front of you today, the division has rejected UPA's suggestions that the division needs to provide written notification of eligibility to adjust their supplemental bond, and we would ask you to reconsider that. Third item in front of you today is an ability for an operator to overbond their well. So also, we had included language under R649-13-3 that an operator doesn't need to obtain a reduction, only for the case of a reduction in the bond amount if they are overbonded, and that language was also rejected and not included in the current draft in front of you. I think we're struggling to understand what risk the state bears by holding more bond than is actually required on behalf of an operator. A few months ago, you heard a division presentation, or it was a presentation from a surety company about how complicated it is to get financial surety. It's complex, it's time consuming, it can involve multiple financial instruments and multiple different assets, including outside of the state of Utah assets for larger operators, multi-basin operators. So if an operator is planning to make a change that would, a few months down the road, result in a bonding increase, it doesn't seem like a good use of the operator or the division's time and resources to require them to go through that process to reduce the bond amount, only to then increase it again a few months or a short period of time down the road. So we would ask for reconsideration there. And then surface bonding was an issue as well. So we feel pretty strongly that there needs to be a cap on the amount of surface bonding. We recognize that this only applies when there isn't a lease or where there isn't a surface use agreement, but currently surface bond amount is $6,000. We agree that that amount can be increased. We are supportive of that. We had proposed a cap of $100,000. If the division would like to see a different cap, we understand that, but to have a uncapped amount of potential surface bond in addition to the blanket bond and the supplemental bond seems to be an unnecessary cost increase. And then the bonding calculator, and since I put this slide together yesterday, this has been somewhat resolved, so bear with me a little bit here. But we do feel that it's very important that a bonding calculator be available with the rule. We did see a calculator released by the division late yesterday afternoon, which we are very appreciative of, but it's given us just a few hours to start looking at how that calculator works. The last bullet here has actually come to fruition in the last few hours. Our point was that the calculator can help make sure that the division and the operators are interpreting the rule in the same way and that the data matches up, and help uncover any potential mismatches in interpretation. And we did indeed find one of those yesterday. It kind of daylighted something we were not aware of before. So that calculator includes a category called wells that are drilling operations suspended. If we understand that calculator correctly, then those wells in that category are being ruled into at-risk wells for the supplemental bond calculation. And our understanding of the kind of universe of wells under this drilling operations suspended category is that it's pretty wide-ranging. Could be wells that are just categorized as not plugged if, for example, there was a downhole location and it wasn't finished. We understand that's an at-risk well. But it also seems that that category would include DUCs, so drilled and uncompleted wells. We fundamentally disagree that DUCs should be considered at-risk wells. There are multiple reasons, again, why an operator may drill and not complete wells. That could be to hold leases. It could be to ensure that there is a large development that is properly addressing correlative rights. It could be to allow infrastructure to catch up. For example, maybe a gas offtake pipeline needs to be completed before those wells should be brought online to avoid potential flaring concerns. Those are highly valuable, not at-risk wells. And so we would just ask for further consideration of how to tease out which wells in that category are truly at risk and need supplemental bonding versus are not at risk wells. And I apologize, I don't have language because we just saw this yesterday afternoon, but we'll include more on this in our formal written comments. So those were our major issues overall. I think that we have made significant progress in the evolution of this. We're much more comfortable about where the rule is today. We appreciate all of the time and effort and thoughtful consideration to make this a balanced rule. But we do still have some concerns with some of those wells being treated as at risk when we don't think that that's necessarily the case, either in this categorization or those division approved TAs and SIs particularly. And I have 1 minute left, so I'll stop talking and see if there's any questions. Thank you.
Thank you, Chairman and members of the board. I apologize for my delay. I was in a meeting that we can talk about offline, but here I am now. Broadly, I would like to remind the board of what the reason was for these rules. It was part of a larger legislative audit that occurred in 2019, and I apologize if this has been spoken to already. Essentially, the legislature gave a number of recommendations back to the division and the board as a result of that audit in 2019. We were able to achieve all of those, and this is the last one we're wrapping up. The legislative in their audit found that there needed to be, or they recommended a revisiting and a revision of our bonding rules to bring them in line with other states while at the same time maintaining a competitive environment. They also recommended us setting a timeline to review these rules as they went on. As of 2019, it had been 16 years since the bonding rules were visited, and it's been 6 years since then. So we're actually, do some quick math, 22 years since then. The legislature recommended, and we support, at least a 5-year regular review of our bonding rules, and really any rules. I think that's subjective, or not subjective, but that's recommended. Other states do that as well. It keeps things fresh, and it sort of breaks out the work, honestly, versus hitting something really hard every 2 decades or so. The bonding draft where we are right now, the division strongly recommends it. We are behind the draft that we provided to you. We also understand that, this is not the end of it. In fact, we haven't even began the formal rulemaking process, which opens up to comments and a period to provide comments and additional recommendations. But where we are now, I know the division has put a ton of work into. This started long before I came. I've been here just under 2 years. They started working on this, I think, in late 19, early 20, and there's been some very, very good work. And I would say conservative but also innovative ideas to make sure that the industry is appropriately bonded to protect Utahns while at the same time keeping Utah competitive. Those are the comments I have. I'm happy to obviously continue to work with the board and our stakeholders as we work through this. And I thank you for this time.
I'd just like to add, if we go ahead with formal rulemaking here, these rules can be adjusted within 5 years also if we find out in practice something doesn't work. So I don't want you to think if something's not working, it's going to take you 5 years to fix it. 5 years, we really go through and make sure everything is correct, but there is an opportunity if there are issues.
Thank you, Chairman. And that reminds me of a couple of other stats that I can say. Our bonding rules, as they are right now, are they should be revisited to make sure they're appropriate. It's worth sharing some affirmation with the team over the past 20 years. Utah is in the top 1 or 2 as far as orphan wells, abandoned wells that the state has to plug and abandon out of state funds compared to production. Other states have significant orphan well problems. Utah, thankfully, through the cooperation, honestly, of operators, the board, and our staff, has maintained a very healthy field. And that's under the current rules. I think these additional rules will provide even more clarity and security for the state.
Thank you. Thank you, Mrs. Browning. We appreciate it.
I have a quick question for her.
Go ahead.
So you presented these 1 through 5. Is that your order of priority?
It
Did you
is.
say? Okay.
Yes.
Mr. Walker.
Yes. Can you help me understand on the TASI, the process to set those up and have them excluded from the at-risk calculation? What does that take from the operator and the division to delineate that or recognize that?
So the process to have them excluded from the calculation would be some definitional changes in the draft in front of you. The process for the division to approve TAs and shut-ins is a sundry. And again, you have an existing rule that walks through the division's consideration in approving or denying that extension of time.
Okay, so there is a process at this point in time using the sundry notice to enable that potentially to be addressed and excluded from the calculation.
There is a process that allows the division to provide a approved temporary abandoned or shut-in well, but in the draft in front of you, all temporary abandoned or shut-in wells, whether division approved or not, are treated as at-risk wells.
Okay, thank you.
You know, and I think there's a problem with TA and shut-in because some will qualify and some won't. Some are at risk and some are not. And so it's a problem in determining which one to go with. You have to go with one or the other and then deal with exceptions. And so there's just kind of an issue with how to make that definition apply to all wells. But we'll take it under consideration. Thank you. Is Adam Peltz here? Hello there.
Hi. I was wondering if it's possible, so Matt LaFleur is here in person. On your schedule list, he's 7th and virtual, and I wonder if it's possible for us all to go together.
Sure. We'll do yours and maybe Matt's and then break for lunch. We're kind of over the...
Well, we also had a vision of Lauren going first. We don't have to do it that way. We can do whatever you like.
How many people are here from out of town? Okay. We should maybe take you 3, but should we break for lunch or do 3? That's 45 minutes.
When's your flights out?
Lauren and I are going tomorrow. Matt flight is at 6.
Okay.
I think we'll be okay, however you decide to do it.
Maybe we
Let's
take
do lunch.
maybe take someone else and then
Yeah.
have these guys go right after lunch.
Yeah, I'm thinking we'll do one more and then you guys right after lunch, if that's okay.
Sure. Lauren, do you want to go first, or should I do?
No, we're going to take somebody
We're going
else.
to,
Oh, someone else entirely?
Yeah.
you 3 can go then after lunch. So that would be Lauren, Lauren's here. Steve Ellis. Is Steve here?
Wouldn't we take swearing signs?
That's the electronic.
Lauren is from out of town. Oh, that's an electronic.
The environmental defense one.
Soren Simonson. Is he here? Steve Ellis.
He's electronic.
Okay. Spencer Kimball. Spencer, are you here? Would you like to do your presentation?
Okay, good.
Please introduce yourself as you're getting ready to present here.
Good morning. Thank you, Madam Chair. Members of the board, great to see you.
Turn your mic on.
Mic on.
Sorry about that. Thank you, Madam Chair, members of the board. Great to see you. Good afternoon or good morning for another 6 minutes. My name is Spencer Kimball, and I serve as the Government Relations Manager for 4 Point Resources. I'd like to thank the board for the opportunity to present here today. 4 Point greatly appreciates the considerable time and work that Director Thomas and the division staff have invested in developing the draft rule and working with stakeholders to meaningfully incorporate feedback. I'd also like to thank Ricky Harenko Browning and Fred McDonald, who have done an exceptional job representing the Utah Petroleum Association, working with the division. By way of background, quickly, 4 Point recently acquired and began operating a 126,000 acre position in the central Uinta Basin and currently operates hundreds of wells of varying production and age. We recognize and support the division's goals to construct a rule that balances reasonable bonding levels for operators of all sizes while managing the state's risks associated with managing orphan wells. Attaining this balance will be critical to ensuring that operators can continue to attract and deploy capital in the state. Today, I'd offer the following specific comments and a few requested revisions. First, we appreciate the division for releasing an updated version of the online bonding calculator, which we assume will serve as the ultimate determiner of our annual bond amount. My comments today reflect our interpretation of the proposed rule as drafted. In order to fully comprehend what we believe our new bonding burden will be under the proposed rule, we do request some additional time to fully understand the functionality of the calculator and to reconcile any discrepancies amongst ours and the division's data sets, which will obviously underpin our bonding requirements. Second, we request the definition of wells currently in, quote, drilling operations suspended category be limited to those that can be reasonably considered at-risk wells as defined in the rule. This is something that Ms. Ranko-Browning brought up a few minutes ago. We understand that there may be circumstances where these wells may present legitimate risks, but we do not believe the handful of 4 Point wells the division shows to be in this category warrant supplementary bond protection, which would significantly increase our total bond. In the case of these few wells, our predecessor operator of the asset set conductor on a few of those, and we subsequently drilled surface sections. Please note that those would not yet be considered drilled uncompleted or DUCs because they have not been drilled down to their target formations at total depth. It is efficient to set conductor and drill surface sections in batches, as you probably know, which may result in some lag time until the wells are drilled to total depth by a big rig. These wells are slated for drilling next year, barring unforeseen macroeconomic or other changes. In another case, our predecessor set conductor on a well, we believe, on a pad we do not plan to utilize in the near future due to DSU respacing in that area, and it is my understanding we intend to plug and abandon that well in the very near future. We believe the wells I just described do not constitute the risk profile this proposed rule aims to address and should not necessitate supplementary bond coverage. So we would respectfully request the board and division work with us to refine the status of those particular wells and whether they truly meet the definition of at-risk state wells and revise the rule as appropriate. We will also work with UPA to provide specific language that addresses these concerns for the board's consideration. We also request another thing that Ricky had brought up a few minutes ago, the temporarily shut-in wells not be considered at risk due to many factors that may bring those wells back into production. Adding these wells would increase the supplementary bond relative to wells that may come back into production in the near term, so we'd respectfully ask the board and division to work with us and UPA on this issue as it continues with the rulemaking. Finally, we greatly appreciate the division's efforts to ensure that the tier classification thresholds in the draft rule reflect the entire population of an operator's wells in the state, as that is a very important element to establishing a blanket bond level that appropriately correlates the risk with at-risk wells as a proportion of total state wells in production. We also appreciate efforts to ensure that wells will not be double bonded if they are also covered by a federal or a tribal bond, an initial concern shared with the division. In closing, pending the specific requested revisions I raised today, 4 Point is very supportive of the rule and will remain engaged with the board and the division as it continues in the rulemaking. I'd like to reiterate our great appreciation to the division for its hard work constructing a well-balanced rule. Thanks again for the opportunity to present today, and I'd be happy to stand for any questions.
Board, do you have questions?
Got to use up the rest of your 12 minutes. Right?
Yeah.
Thank you, Commissioner.
The ones that have the conductor set, how deep is that?
I would have to check on that. You know, that's
you're just down a ways, right? That's
conventional conductor. In some cases, those do have surface casing set, but the big rig has not moved in. Those are typically done by the smaller sputter rigs.
Yeah, so perhaps there's a way to if they're only down so far, you know, set a number that's reasonable and they could be excluded, something like that. Was
Yeah.
just a thought.
I would say some additional granularity within that definition of drilling suspended operations wells would help alleviate that, and it would more than likely address, you know, the 3 or 4 wells that we have that would be identified as that category and would therefore be included on our at-risk category.
Mm-hmm.
Do you have a rough, Spencer, thanks for coming today, do you have a rough number as to how many of those wells you would like to have excluded from the at-risk calculation?
So yes, the ones that I just listed off that are in that drilling suspended operations category, I believe we have 4 that are categorized as that by the division. And based on the concerns I presented today, we would hope that those would not be included as are at risk. As it stands, those 4 move us into a higher category within our supplementary bond amount, and it would increase quite exponentially the amount of supplementary bond that we would have to carry beyond our blanket bond amount.
Okay. And how much of a burden is it to file these sundries, to have a sundry approved by the division on these 4 wells that could be excluded?
I don't think that would be a big burden at all, Commissioner. I think we could work with our regulatory teams to make that happen, just to clarify the status. I think we were a little bit surprised when we saw that show up. It is in the draft rule. It is included in the definition of, I believe, state well, which is it's included in the definition of at-risk well. But I think we were just a little bit surprised to see it in the calculator when it was released yesterday afternoon.
Okay. I got to understand, though, that the division's seen lots of games played with TA and SI in the past, as have I played some of those games. And so an approval process might be something that meets the needs there. So, okay. Thank you.
Understood.
Division, do you have any comments at this point? No? Thank you.
So yeah, to clarify though, you've only had this the calculator for a day or so, and so you're just requesting more time to really vet it out. And
Right. We just want to square all the numbers on the production, the at-risk well side, the total number of wells applicable with what the division is utilizing in the calculator. I don't foresee a big discrepancy there. We just want to ensure. But I will say that other than those 4 wells I just described, the calculator correlates well with what we assumed our bond would be based on the draft rule and all the various changes that have occurred within the draft since we first saw the calculator, which I want to say was about 6 months ago.
Okay.
And change the 4 wells, change the tier and significantly increase the bond?
It didn't change the tier, Commissioner. Thank you for the question. But it did move us over a certain threshold within the supplementary bond amount, which triggered that supplemental bond to go up by quite a bit.
Board, any other questions?
Just a quick one. How much time, and Ricky mentioned it too, since the calculator was just released, how much additional time would you anticipate that you would need to assess properly what the impact is?
Thank you, Commissioner. I don't foresee we'd need a lot of time for that. I think that could be done within, the scope of the rulemaking as it is now. We do appreciate that calculator is out. I think, 4Point and other operators will just need, a week or so to just really understand how that will work. And if they do understand or come to see any type of discrepancy within the data, or it's manifesting a number on the bond that they think would be different based on the rule as drafted.
Any further questions?
So ballpark, when you say substantially increased the bond value with those 4 wells, what are you talking about?
It increased our overall bond, which includes the blanket plus the supplement, by about 50%, just those 4. So pretty significant.
I guess I have maybe not a question of you, but Mr. Thomas, we may want to take a look at what you think the administrative burden is upon the division if we take a look at the sundry notice procedure that may or may not change these things.
Chairman,
You don't need
Vice
to
Chair
tell me
Walker,
now, but yeah.
generally, I recommend this moving forward. As we hear the comments today, our staff and myself are taking notes. It's probably most efficient if rather than we, engage real time, that we put together a response and provide that to the board holistically. That should help a little bit if you don't mind. All right?
That'll be fine.
Thank you. Thank you.
And just one note of clarity on the drilling suspended operations discussion. That was something we just noticed yesterday. So we haven't had time to work with Director Thomas or division staff on this issue, but we did want to raise it before the body today.
Great. Any further questions? Okay. I think we will break for lunch. Can we do a half-hour lunch, you guys, or do we need 45 minutes? Half hour is good? We'll try to come back a little after 12:30, and we'll start with Adam, and then to Lauren. Who? Okay, sure, sure. And Matt, wherever he, there he is. Okay, 2, 3, 4. Okay, we will see you in a half hour.
one.
And if we can get a timer put up here. First person on the list is Adam Peltz. And could you introduce your, oh, Lauren.
Yeah, so
I'm sorry, Lauren Beatty.
yeah, so we have a three-parter here from the Environmental Defense Fund.
You're tri-teaming us here with
So we can cover a bunch of issues that are of interest to you. And so I should say, overall, we are supportive of this rule and this process, and we think that it's on the right track. And we're going to get going, and I'll hand it to Lauren to start, and I'll screen share for all three of our presentations.
Yeah, could you each introduce yourselves, please, for the record?
Hi, my name's Lauren Beatty.
And you're with whom?
I'm with the Environmental Defense Fund.
Thank you.
Good afternoon, Madam Chair, Commissioners. My name is Matt Lepore. I am the founder and principal of Insight Energy Law, which is a policy and legal firm, and I'm representing EDF here today.
Thank you. And
I'm Adam Peltz with the Environmental Defense Fund.
Thank you. Okay. Lauren, please commence.
Hi, thank you all for having us. My name's Lauren Beatty. I'm not a geologist. I'm not a lawyer. I'm an economist. And what that means is that I spend my days trying to sit down and write models about how profit maximizing firms respond to prices and respond to policy. And then I look at data and try to fit those models. And today I'm going to try and give a high-level overview of the current state of oil and gas in Utah and what that implies about the current threats and opportunities for Utah. And then after that, I'm going to step back. I'm going to give an overview of the insights from the academic economics and public policy literature and what those insights mean for real-world policy. And then I'm going to try and contextualize the current rule within those insights. So first, here I've plotted on the left. I should note all of these plots are my own creation, so I've been using publicly available data to make everything you see here, and my own interpretation of the regulation. On the left here, you'll see a plot of Utah's well population over time. So, wells are entering and they're also exiting by plugging, and I've colored it by vintage of the well. And on the right, you'll see oil production over time, also for different well vintages. And the point of this is that Utah's well population is aging. So there's a really, really large chunk of the overall population of wells that's growing old. And on the right, you'll see that corresponding population, their production is declining. Right now, most of the oil production in the state is really driven by very new wells. I think that highlights both a threat because these old, aging, and declining production wells are going to, threaten to be orphan wells in the future. But it also presents an opportunity because production today is at an all-time high. So now's a really great time to think about setting aside money to prevent there being a problem in the future. Now, I think you can go to the next slide. You've probably heard that orphan wells aren't really a problem in Utah, but it's not my perspective that Utah is immune to orphan wells. It's just very young in its production history. So on the left, I've plotted the cumulative wells completed. So I look at individual API 10s and the first date that they were completed. And I've plotted years since passing a 5,000 mark threshold. You can see that, Utah might not be so different from Colorado or New Mexico. It's just a bit younger. It's just a bit earlier. So, this is Enverus data. There's not particularly good data on wells drilled before the 50s, so take the numbers on the right with a grain of salt. According to my calculations, Utah didn't pass the 5,000 well threshold until 2004. Texas passed that back in the 30s. New Mexico passed that in the 50s. Who knows where we'll be in 20 years, and that's why coming up with good regulations now is so important. So now the economics and public policy research. I think the first paper is called Mandatory Insurance and the Judgment Proof Problem. This is economists thinking about how you can incentivize firms to reduce risk, especially in cases where, you know, some sort of accident might cause them to become potentially insolvent. That's known as judgment proofness. So this was a theory paper, and it just showed that in these sorts of contexts, mandatory insurance, which is really the same as you know, bonding in a lot of contexts, can actually force firms to incentivize them to internalize some of that risk before anything happens. The next paper is by Lucia Muhlenbach. She's an economist in Alberta, and she looked at the plugging decisions of firms and came up with a model that showed that operators in Alberta will tend to use temporary closure as a way to punt on the high upfront costs of plugging. And the last paper is a paper by Judd Boomhauer, which shows that bonds work. So, you know, he shows that when you create bonding, you internalize some of the moral hazard associated with the judgment proofness problem. So putting that all together, what can the economics and public policy literature tell us about what good policy looks like? I think one insight is that good policy thinks of bonding as an insurance or actuarial problem. There are small probability events that could be potentially very costly to the state. And the second thing is that good policy should incentivize operators to plug their wells that have reached the end of their productive life rather than punt on the high upfront costs of plugging. So the current rules are insufficient. I don't think they meet either of those goals. It seems to me that most operators in the state are required to submit a $120,000 blanket bond. And this plot is showing on the x-axis the current bond that they should have to submit, and on the left the potential liabilities posed by the sum of their fee state plugging liabilities. And you know, the conclusion here is that firms that are submitting this $120,000 blanket bond could pose anywhere from, you know, a $120,000 risk to the state, anywhere to about a $100 million risk to the state. So it's not accomplishing the goal of incentivizing plugging, and it's not keeping, you know, potential liability somewhat proportionate to protection. And here's my calculation of different operators, what they should have to submit under this current proposed regulation against their probabilities. And I think, you know, broadly speaking, though we have some issues with the current proposed regulation, it meets the characteristics of good policy that I described to you. So good policy should incentivize plugging, and it should match you know, liability with protection. So, you know, matching liability with protection, you would want lots of firms to be submitting bonds that are about equal to their potential risk. You know, I've drawn a line at y equals x, so you think that points near that line are firms that are submitting bonds that are approximately equal to the risk that they pose to the state. And it incentivizes plugging. You know, you'll see that the tier 1, tier 2, tier 3 firms usually are receiving substantial discounts on, you know, the bonds they're required to submit relative to the risks they pose to the state. For also, just for clarity, tier 4 is no tier. So those are operators that don't meet any tier requirements. Yeah, next. And just to sort of hammer this home, you know, here I've plotted the mean increase in bonding amounts between current and proposed rules, but I've broken that up between operators that have less than 20% of their wells at risk and operators that have more than 20% of their wells at risk. And the point here is that the proposed regulation increases bonds more for operators that have more than 20% of their wells at risk. Again, good incentives. If you want to reduce your bonding amounts, plug some of your wells, reduce the risk to the state. So, to conclude, I think Utah has an opportunity to reduce the risk posed by the current stock of aging wells. I think that good policy will match risk with bonding amounts. Thinking of the overall problem as that of like an actuarial problem. Good policy will incentivize plugging to reduce risk. And the current regulation has a lot of design features that match those characteristics that I consider good policy. That's it for me. Thank you.
Thank you. Board, do you have any questions? Seeing no questions. Mr. Peltz, we'll move on to you.
In fact, I'm hoping that we can go to Mr. Lepore first,
Okay.
if you don't mind.
Okay.
And so let me get that teed up. Does that all look right to you? Great.
Good afternoon again, Commissioners. Matt Lepore. I will tell you a little bit about my background, a little bit more about my background. From 2012 to 2018, I was the director of Colorado's oil and gas regulator, then known as the Colorado Oil and Gas Conservation Commission, now known as the Energy and Carbon Management Commission. Prior to that, for 2 years, I was an assistant attorney general for the Colorado Attorney General's office representing the commission. In my current role as a consultant, I have represented state governments, local governments, EDF, large operators, and small operators. So I have a pretty broad sweep and a pretty broad perspective on issues like financial assurance. I hope we've communicated to this point that we think the division's proposed rules are good. They are certainly far better than where we started from. But there's opportunity for them to become better from our perspective, meaning reducing the risk of orphan wells and the liability of those orphan wells to Utah taxpayers. And if nothing else, we're here to ask you to kind of hold the line at where we are today. So the first topic I'd like to hit, this slide, the graph, was presented to you by staff in the February 2025 presentation. And what the graph shows is that the longer a well remains idle, the less likely it will ever produce again. So that's the downward curve. When you get to 5+ years, there's less than a 1 in 5 chance that that well is going to produce. That's why the focus on idle wells. That's why we call idle wells more risky wells, or very low producing are more risky wells. Can I go to the next slide? So you heard the industry representatives ask that approved shut-in or temporarily abandoned wells not be counted as at-risk wells. And the logic there is that those shut-in or temporarily abandoned wells don't present greater risks to the environment, public health, safety, and welfare. That's not the risk we're trying to protect against with supplemental bonding. The risk is an economic risk. The risk is that those wells will not get plugged and abandoned. They will not produce product again. They will not generate revenue. So it's an economic, financial risk, not an environmental risk. The division up to this point has declined to remove those wells from the definition of at-risk wells. And I'd like to ask Adam, if he can, to bring up the applicable regulation, which is 649.336. I think this is important. You asked a couple.
Yes, thank you.
You asked a couple of questions about the process for the extension and the placement of these wells into approved. So the first fact is the well must have been TA'd or shut in for 12 months already. So this is not the circumstance where industry has a legitimate maintenance issue that they need to fix. That's fine. We understand that. That happens. But this is a well that has already been shut in for 12 months, and now the operator wants to extend that period for up to 5 years. And this takes us back to that graph, right? The well is not, it's going to be shut in or TA'd for 5 years. If the operator wants to bring it back into production or wants to plug it, they can do that, and then they can take it out of this status, and it also comes off their at-risk well list, right? They no longer pay that supplemental bond. But I think the important thing is to understand you're putting that well in this sort of offline status for up to 5 years. And the only thing that the division is looking at is in 1.3, an explanation and supporting data showing the well has integrity. So that's what they're looking at. They're looking at mechanical integrity for these wells, not the financial burden or aspect of the well to the operator's portfolio. Yeah, you can go back at them. And you can go to the next slide. Okay, next item for us is what we think is just a Scrivener's error. So there's a difference in the definitions of the average BOE per day production under 649.13.4 and 649.13.3. I've put 649.13.4 first. The highlighted text, 1,000 BOE, this is for Tier 1, 1,000 BOE per day average is the production threshold. If you look at 649.13.3, after 1,000 BOE, the per day average is not there in the rule. So that's my insertion. We believe that is the way it was meant to be and really the way it has to be. If it's only 1,000 BOE for an entire year, that's a very, very low producing well, and virtually all your wells, all your operators will be Tier 1 operators suddenly. So just want to make that clear. We think it's just a Scrivener's error. It should be a per day average. Okay, next topic. Industry has asked at different times that the tier structure only count production and not include an at-risk well ratio. I don't think I heard that from them today, but we believe that that at-risk well ratio part is incredibly important. It's like I'm going to do my budget and I'm only going to count my income, and I'm not going to look at the mortgage payment or the streaming service payment or the utility bills or anything else that I know I have to pay out of pocket. The at-risk well ratio is the liability side of the operator's overall economics. It's a proxy for that liability that they have. Taking that out just gives a very skewed picture of what the operator's actual economics are. We stand firm on the proposition that operators with a high percentage of very low producing wells, 1 BOE is the at-risk well ratio, is very, very low. We started out in the dialogue that we've all been having for several years at 2 BOE. Now it's 1, very low. Operators with a high percentage of those wells represent a higher risk of abandoning or orphaning those wells, and that should be accounted for in their tier stature. I think if we look across the country, in late 2014, early 2015, there was a large collapse in the commodity price. I know some of you remember that. Rig counts went down by 60%. The price of oil went down dramatically. And that's when oil and gas regulators around the states started looking at the inventory of low producing wells and orphan wells and became fairly worried about how we're going to address that. And the real culprit has always been blanket bonding, right? The fact that you can have a fixed sum cover hundreds or even thousands of wells. So the effort here is to match the required financial assurance with the risk And for that reason, blanket bonds should not be a right. They are a privilege that should just be extended to the operators that have the lower risk. And again, we think overall the structure is good. The at-risk well ratio is inventive and we think will be effective, but you have to first not take it out entirely, certainly, and then make sure that it applies, sort of to the right number and percentage of wells. We're both troubled and confused, to be honest, about the carve-out that has been introduced for a certain percentage of an operator's at-risk wells to be covered by their blanket bond, okay? So an operator, low-risk operator, high production, relatively low percentage, is going to be allowed to cover 20% of their at-risk wells under their blanket bond, okay? Conceptually, we're okay with that, but we think these numbers are too high. These percentages are too high. They're compounded by a fact that you're rounding down to the nearest 10 when you look at the operator's number of at-risk wells. So that further reduces this. These numbers are high compared to the only other state that has something like this, which happens to be Colorado. I know people don't always want to hear about Colorado, but Colorado has a similar structure, and the percentages are 10% for the very, very best operators, 5% for the next tier, and that's it. Under the structure, operators, to be in tier 1, you can only have 20% of your wells at risk. If 20% of your wells are also exempted from supplemental bonding, it means that tier 1 operators never pay a supplemental bond amount. Now, I think the argument will be that they are low risk, those tier 1 operators. That's a fair argument. The flip side, the downside, is that they should still be incented to either plug and abandon those very low producing wells or return them to production. And if you take them out of this at-risk supplemental bond, you take away those incentives. Another pretty standard course of action that all states have seen that I know of is that those lower producing wells get passed down from a good operator, a tier 1 operator, to a less well capitalized operator, where their fate becomes a little less certain, right? If they get passed down, they get less likely to ultimately be plugged and abandoned. So incenting them to plug them or return them to production while those good operators have them is a good policy decision. Next slide, please. Tier 2 and Tier 3, I think it's pretty straightforward. There is a higher risk percentage there, higher level of these very low producing wells. They should have higher bonding to match that risk. And then again, I've just reiterated that the carve-outs are exacerbated because we round down. So I gave an example at the bottom. A Tier 2 operator with 100 state wells, 22 of them are at risk. 13% or 13 of those wells are covered by the blanket bond. So now they have 9 that should see supplemental bonding. But we round down to the nearest 10. So they will bond 0 of those wells under the supplemental bonding, as we understand it. Okay. Again, this is borrowed from the division's presentation to you in February. This is their slide. I haven't modified it in any way. What they were attempting to show, the red line at the bottom shows the liability versus available orphan well funds. You are going to be pretty deeply in the red by 2031. And then the blue line at the top shows that with the rules then in place in February, you would remain in the blue, in the above the 0 line or just below the 0 line all the way through 2031. Again, that was assuming the February rules were adopted. The February rules have been tamped down a bit to where we are today, so it won't quite be as rosy as that blue line. It certainly won't be as bad as the red line either, but this is why we're sort of saying, let's hold the line where we are. Next slide, please. So here are our proposals for holding the line. First, of course, shut in TA'd approved wells should be at-risk wells. They should not be excluded from that. If you want to keep the carve-out of a certain number of shut-in wells being covered by the blanket bond, we would recommend that you reduce those percentages by half. An alternative to that would be to not round down to the nearest multiple of 10, so that the example I gave you with 22 wells, 13 of which are exempt, they're still paying the supplemental bond on those 9. There's lots of ways to slice and dice this. You have some time. You will have time to think about it. Next slide, I think. This is the last 34 seconds countdown. If you stay where you are, you're in a very good place. There have been some reductions in the protection since February that I mentioned. One is originally at-risk wells were 2 BOE, now they're 1. Originally, the at-risk supplemental bonds were substantially higher for Tier 2s and Tier 3s, and there was no at-risk well carve-out in February. So further reductions will leave the Utah taxpayers exposed to a little bit higher financial risks. Thank you very much.
Thank you. Mr. Peltz,
Unless any of you have questions.
you don't want to present?
Oh, well, if you had questions for Matt that he might
Oh.
be able to answer now.
I'm sorry. Questions for Matt? Yeah, I think we're ready to move on.
Great. Well, so I'm going to provide a bit of a national perspective of what's going on elsewhere in the United States so that you all have that as you think about what you're all going to do here in Utah. So this is a map of documented orphan wells across the United States as of late 2021. That's the last time we were able to collect the data. This shows that the largest part of the problem is in Appalachia into the Midwest, and then in the southern central part of the U.S. You can see the Rocky Mountain region doesn't have quite as many, but there are certainly plenty scattered around New Mexico, Colorado, Wyoming, Montana, and even Utah, and then again into California. And the total count right now is 141,000 documented orphan wells. There's thought to also be maybe 1 million undocumented orphan wells across the U.S. So this slide shows some polling that was done in western U.S. states where respondents were asked, do you think that operators rather than taxpayers ought to pay for cleanup and restoration? And notably, Utah has the single highest percentage of support for that among all the states. It's pretty high across the board, but I thought it was notable that Utah was in fact number 1 on this issue. Although I think we generally all agree that this is a good idea. It's just a matter of how. So let me talk you a little bit through Texas. Texas passed legislation this year to limit how long wells can stay idle to 15 years. This was after there were so many blowouts in the Permian Basin from shallow wastewater disposal through legacy wells that the Railroad Commission had to ask for $100 million from the legislature to deal with blowouts. And the commissioners said to industry, you got to do something. And so they came up with an idle well limitation bill, and there's going to be a series of rulemakings at the Railroad Commission through the end of next year on this. They'll also be issuing an annual idle well report. The orphan well count in Texas recently passed 10,000 for the first time in at least 15 years, so that's not a great track record. And then I'm also going to show you momentarily a map that the Bureau of Economic Geology did looking at the intersection of legacy wells and carbon sequestration intervals. You know, CCS came up earlier today. So in Texas, you can see that there are 77,000 non-marginal wells, but most of the wells in the state are either marginal, inactive, or orphaned. Here you can see, this is a very similar plot to what Lauren showed. Or actually, no, this is a different plot. I have one that looks like a little bit later. This shows that the inactive well problem in Texas started spiking around shale development, and it's getting a little bit out of control, and that the vast majority of the wells have been shut in for a long time. This plot shows that the next generation of inactive wells, and thus orphan wells, is here with us already. This shows all of the marginal wells in Texas, and the lighter green is those that produce less than a barrel of oil a day. So there's 60,000 of those in Texas that are kind of sitting around waiting to fall on the public to deal with. Here we looked at job creation. I think it's worth noting that increased well plugging does mean more jobs for more people. The Railroad Commission estimated that plugging all the state's inactive wells would cost $15 billion. We calculated that doing the work would generate $19 billion in direct and indirect wages. And that doesn't count increased property values and better use of the subsurface. So plugging wells is job creation. And this is the maps that I was talking about a little earlier. The BEG looked at legacy well bores and likely carbon sequestration intervals in all of Texas's counties. And on the right, you'll see the orange indicates that legacy wells do penetrate those likely storage formations. And so there's a tension between the legacy production in any state and future uses like carbon sequestration. And so you have to clean up the old to make room for the new. Louisiana enacted increased idle well fees in 2023. Those fees increase over time to incentivize operators to plug their wells. Nevertheless, a 2024 legislative audit found deficiencies in the state's approach on financial assurance, idle well management, and well transfer, not unlike the 2019 legislative audit. Here, they also found that their orphan well closure fund was being siphoned away by a corrupt official. And so there was a big overhaul legislatively this year. It reorganized the agency there. They set up a natural resources trust authority to collect money from operators to support well plugging, and they plan on doing a better job on compliance. Some of Governor Landry's support was because there have been a lot of lawsuits against operators for abandoning their wells. Those have come both from the private sector and from the ENGO sector, and it was getting kind of out of hand, and it was a bad look for the state. And so Landry came to the legislature and said, it's gone a little bit too far. And I've included at the bottom, the Louisiana Register includes an orphan well count every month, which I think is maybe unique in the country. And so it's wildly all over the place. June had 1, July had 175, August had 1,000. September went down, but then October was back up to 400. And so wells are being orphaned at a tremendous rate in these legacy production states. In Oklahoma, similar to the Texas bill, Oklahoma passed a bill that limits the length of well idling to 10 years. There are inactive well rules underway. They also did mild reforms to their financial assurance. They are well behind the times. A national lab paper found there are likely 325,000 undocumented orphan wells in that state. Coming up this year, we get the sense that the legislature and the regulator is going to be looking at putting more state funds into well plugging. There's the issue of saltwater purges in Oklahoma has come up as well. This is where various types of UIC injection have been causing blowouts in abandoned wells. This is what it looks like. There's some more gruesome photos, but I just wanted to stick to the ones of water coming out the wells. Nobody wants this. This is terrible for the land, and this is now in the news with some frequency there. Let's see. In New Mexico, so New Mexico is going through a rulemaking, not unlike this rulemaking right now. It is very contemporaneous. There was a hearing that started in mid-October and went to early November. The proposal was initially submitted by the Western Environmental Law Center, and the Oil Conservation Division there provided some red lines, and it was resubmitted to basically match what the agency wanted. It was patterned in many ways off of early drafts of the rule proposal here. And so there is a kind of a parallel movement with your sibling state down in New Mexico. What's been proposed there is much more stringent than what's been proposed here. $150,000 well bonds for inactive wells and marginal wells as defined, which is less than 1,000 BOE per year and less than 180 days a year. They came up with 150,000 because the average cost for the state to plug wells in New Mexico is 154,000, which is high, but that's what it costs. They would also require operators that have more than 15% of their wells in this status to pay single well bonds on all of their wells, limit inactive well to 8 years, and have heightened scrutiny over well transfer. There are negotiations going on right now between the agency and industry and ENGOs. The commission will be meeting in January to discuss, and rules expected in February or March. These are some exhibits that were included in the hearing. They have an ornate process where everyone has to get together for weeks and do, it's very formal, and there's cross-examination and the whole bit. And so there's a lot of public record on this if you're all interested, but this is the plot that looks a lot like Lauren's plot from here. It's the same story in New Mexico. It's the newer wells that provide most of the production, and older wells provide very little, and but they do stand for a lot of potential liability. The rule as proposed in New Mexico is risk-oriented, much like the rule proposed here, and you see that the higher percentage of, call them at-risk wells that an operator has there, the closer to full cost financial assurance the rule would provide. And operators that have fewer risky wells in their portfolio would pay pennies on the dollar for their coverage, which makes sense because that is a risk orientation. This is my last slide. I just found this so astonishing. And so the Wolfcamp formation in the Permian is productive kind of beyond belief. And so the new wells that are being drilled there are incredibly productive. And so these top 9 wells each produce over 780,000 barrels of oil equivalent per year. Each one of them alone produces more than the entire fleet of marginal wells in New Mexico as defined. So there's 4,000, that's a population of 4,000 wells, which represent hundreds and hundreds and hundreds of millions of liability. Each one of them alone produces less than one of these new Wolfcamp wells. And so, out with the old, in with the new. And so that's, I think that, there was one more slide here. So those states are actively working this issue right now, but other states, as Matt alluded to, have been addressing this issue for the last several years. So Arkansas kind of pioneered an approach of requiring single well bonds for marginal wells on transfer back in 2018. They did this because they saw that these wells were getting transferred and then getting abandoned, and landowners were unhappy, including one landowner who happened to serve on the commission there. And so since they've adopted that rule, well orphaning has gone down, bond amounts have gone up, and transfers to micro operators have gone down. So they see a systemic reduction in risk. Wyoming requires single well bonds for all of their inactive wells. They had a big problem with their coal bed methane wells getting orphaned. I think they had something like 2,200 of those. They've been spending both state and federal dollars for some years plugging those down. Tom Kropatch is a good person to talk to about that, the director of the agency in Wyoming. And North Dakota limits the number of inactive wells on a blanket bond to 7, I think for very similar reasons. These states have seen there's a structural risk in these inactive and very low producing wells and have attempted to reduce the risk by requiring bonding that's more fixed towards the actual cost of plugging. And so that's what's going on in the United States on this issue. And I don't have a slide on this, but I'll just share that we've only been talking about state rules and wells that are on state and private land. Federal lands is a different story. And of course, here, that's a big deal. It's half the wells. There was a rule that was adopted a year or two ago that increased financial assurance on federal public land fairly significantly. That rule is currently being revisited. And so there will surely be less bonding for federal wells coming down the pike, but you all have an opportunity to be protective about the wells on state and private land. And so I'll stop there.
Thank you. Board, do you have any questions for any of these witnesses? Seeing none, thank you for your presentation.
Great.
We'll take it under consideration. Oh, we have one question.
Well, I don't have a question, but I did want to thank you all for coming in personally rather than your electrons. It does help that we can see how dedicated EDF is to our process out here. And we're a long ways from New York, and I do appreciate that you're interested in what we're doing here. Thank you.
Yes, very much so. Utah's poised to be a leader of the nation on this issue, and you all should be very proud of that.
Thank you. Thank you. Okay. Let's see. Next on the list, we have Soren Simonson. Is he here? There we go. Could you introduce yourself and tell us who you're with, please?
Thank you. I would be happy to. My name is Soren Simonson. I work just down the road, so this was a convenient location to come and meet with you today. I am here, people may know me in other capacities. I'm here today officially representing an organization that I was involved with founding back in 2012, which is called the Mormon Environmental Stewardship Alliance. We're a nonprofit, nonpartisan, faith-based advocacy community that's working to address some of the real and present challenges that we face both here in this community, across Utah and across the western United States, but really many of the things that we are working on, from climate change and air quality to water conservation and stewardship of natural resources, are things that we are aware of that need a response all over the world. Our organization includes people from all different walks of life, all different backgrounds. As members of the Church of Jesus Christ of Latter-day Saints, environmental stewardship and conservation are among the core values, beliefs, and doctrines of our faith. I know it may be unusual receiving commentary that may focus more on faith and religious values, but they are values that drive so many people in our community who share a common faith and heritage. Our movement was born in 2012 out of the tension between two prominent members of our faith community. You may recall Senator Harry Reid of Nevada, who was the leader of the U.S. Senate at the time, a very prominent member of the Church of Jesus Christ of Latter-day Saints, and Governors Mitt Romney and John Huntsman Jr., who were at the time both in a race for the U.S. presidency, with Governor Romney ultimately becoming the Republican nominee. We are here to try and bring awareness that even though we may be separated by political backgrounds and persuasions of all different kinds, we share many common values. These are not unique to the Latter-day Saint community. Pope Francis and Pope Leo of the Catholic faith have been very outspoken commentators in recent years about tackling the climate crisis and addressing real environmental risks and concerns as part of our faith-based stewardship, both for the earth, our common home, and for each other. Our movement was inspired by a comment made or a talk given by our former church president Russell M. Nelson in April 2000. He said, as beneficiaries of the divine creation, what shall we do? We should care for the earth, be wise stewards over it, and preserve it for future generations. And we are to love and care for one another. President Dallin H. Oaks, who was just recently sustained as the new prophet and president of our church, the Church of Jesus Christ of Latter-day Saints, gave a commencement address at BYU, Hawaii in 2017, where he said, "These are challenging times filled with big worries, wars and rumors of wars, possible epidemics of infectious disease, droughts, floods, and global warming." How prophetic was that? Seacoast cities are concerned with the rising level of the ocean, which will bring ocean tides over their doorsteps or over their thresholds. Global warming also affects agriculture and wildlife. We're even challenged by the politics of conflict and the uncertainties sponsored by the aggressive new presidential administration in the world's most powerful nation. Now, I don't believe that this is an established policy on matters like climate change and environmental degradation, but it's impossible to ignore the increasing voices from faith leaders coming across many faiths all over the world, and including in our own community. Just in the last week, our governor, Spencer Cox, was interviewed by Steve Inskeep on National Public Radio while he was participating in the Western Governors Association meeting in Arizona, where he talked about faith being a driver of policy and also trying to bring people together to work through challenges. So I offer this as context. I am not a specialist in orphan wells and in oil and gas and mining, although I have worked around conservation and stewardship much of my adult life, both professionally and personally. I've tried to inspire friends and neighbors, family, my children, my parents, and others to be responsible. I will add also that we often talk about resource use in the context of economy, and that word has an interesting root. We tend to use that word as it relates to financial matters, which are, of course, very important. But the term economy comes from Greek and Latin roots that mean caring for our home. And really, caring for our home is not just looking at the finances that support endeavors related to human health and well-being and prosperity, but they're also about caring for the resources that support what we do, but also can have negative consequences if not thoughtfully approached. So I want to just offer as my testimony in the hearing today, as you're considering rules around bonding, that there is this tension and balance between thriving economies and health and well-being, not only of people, but of our planet. I have tried to familiarize myself with some of the background and information related to the rulemaking that you'll be doing in the coming months. And I believe that there's a lot of balance in not only finding ways to productively use resources, but also recognizing that there are consequences to the use of resources that are not thoughtfully and carefully utilized to avoid waste and harm to the community, but also to make sure that we're not leaving lasting impacts that have negative consequences for people that work around these resources, that live in the communities that are directly impacted, and the future generations that may be impacted. I'm grateful to have listened to the testimony that you just received from many people that do have great expertise that I don't have, but I will just echo that we encourage you, I encourage you, our organization, which has thousands of members and participants, encourage you to think carefully about balancing the need for economic well-being and prosperity with the earth that we leave to the next generation, and encourage you to take the appropriate steps to balance and harmonize the use of resources with responsibility, with efficiency, with not leaving things that have negative consequences for future generations and the communities that are most impacted. Thank you for the work that you're doing, the service that you provide to our community, And we encourage you to make wise choices to support the well-being of our community now and in the future, and to find ways to responsibly balance resource extraction with the need to preserve and sustain the well-being of our planet and of the individuals that can be impacted by the extractive industries that we're talking about. Happy to respond to any questions or comments you may have. Otherwise, that's my testimony today. Thank you for the time and attention.
Yeah, I'd like to just say I appreciate you coming and talking to us about this. And certainly that was a charge from the legislature several years ago, was to strike a balance between protecting the state and the environment, yet encouraging mineral development in the state, which is very important to the state economy. And so with these new rules, we have tried to take those things into account and to really charge the Division of Oil, Gas, and Mining with some of those things. So we appreciate you coming.
Thank you. Appreciate your time.
Board members, do you have any comments for Mr. Church?
Yes, Mr. Simpson. Would you clarify what is your relationship, your organization, to the Church of Jesus Christ of Latter-day Saints?
We don't have any direct relationship with the Church of Jesus Christ. We're an independent nonprofit, a 501c3 that was organized now almost 15 years ago in 2011, 2012, when we were formally created as a nonprofit organization. We are largely members of the Church of Jesus Christ of Latter-day Saints, trying to advocate for around environmental issues, from a healthy Great Salt Lake to healthy air to healthy land and conservation of resources like water and natural lands. But we are not affiliated directly with the church.
Do we have any other questions? Thank you for coming. Appreciate your interest in this matter and for coming to speak before us. So the next person we have on the list is Steve Ellis, and it says electronic appearance. Is he on the line or here in person?
He's not online at the moment, no.
Okay, we're going to move on then to Ashley Korenblatt.
She is online, yes. I'll bring her up.
Hi, everyone. Can you hear me?
We can. Thank you.
Okay, thank you so much. Thank all of you for serving on this board, and I appreciate the opportunity to comment.
Before you start, are you aware of our rules here? 15 minutes for discussion. And if you would please, before you start, introduce yourself and your organization.
Absolutely. And I won't take nearly that much time. So my name is Ashley Korenblatt, and I'm representing Public Land Solutions. We're a nonprofit recreation economy consultant, and I live in Moab, but I've been working all over the West with communities that are, we work with communities that are seeking to add or improve the role of outdoor recreation in their economic development strategies. And this process begins with the recreation review, which includes an analysis of on-the-ground recreation opportunities. It includes planning to work around resource extraction and many stakeholder meetings to incorporate the interests and goals of the residents, businesses, and elected officials. The purpose of the recreation review is to optimize outdoor experiences available in gateway public land communities and ensure that any recommended infrastructure investments will meet the needs of both the community and its visitors while providing a strong return on investment. Demand for outdoor access has become a mainstream economic driver, and public land communities of all types are now utilizing access to quality natural landscapes to attract both tourism and general business investment. I can't emphasize this enough. Outdoor recreation is communities with access to the out of doors are not just attracting visitors, they're attracting professionals, entrepreneurs, divisions of corporations. There are many ways in which the quality of life that comes with outdoor access is supporting economies of communities of all types. Because businesses of all sizes seek to locate where quality of life will aid employee recruitment and ensure employee retention. many communities who have long depended on resource extraction of all types have begun to plan for future revenue generating opportunities to supplement job creation and tax revenue as energy markets evolve. So while Utah currently has a relatively low number of orphaned wells compared to New Mexico and Texas, as producing wells age, Utah is poised to see the same type of increased landscape degradation from idle and at-risk wells, which neighboring public land states have experienced. The effect on air and water quality, as well as view sheds and property values, can put nearby communities at a distinct disadvantage as they work to utilize public lands for new revenue drivers in both the medium and the longer term. This inevitable growing population of aging wells leads to increases in idle and low producing wells, particularly when ownership of these wells are transferred to local operators with generally lower capitalization. Without regular bond review updates like you are now working on, both the financial cost to taxpayers and the opportunity cost to nearby communities will continue to rise. Utah is uniquely positioned to benefit from the ever-growing demand for the quality of life that access to natural places provides. The state has the opportunity to gain from current resource extraction opportunities while simultaneously planning for eventual energy market changes. To achieve this, Public Land Solutions supports adopting the bond requirements in the division's February 2025 R649-13 bonding draft. While other versions have been presented, the February proposal will incentivize all operators to manage their assurance obligations through timely plugging and reclaiming at-risk wells or choosing to increase production. By adopting the February proposal, Utah can lead in this very important category. Future economic opportunities for Utah communities can be safeguarded by taking this action now. So thank you so much for the time and again for your service on this board.
Thank you so much. Board, do you have any questions? I just, I don't have a copy of the rules in front of me, but if you read through those rules, there are also transfers of wells are better set out in terms of going from one operator to another. As you continue to read that, I think we've toughened up those requirements. And so that should add to your mindset that we're doing everything we can to watch out for the state and who's coming in to work with us. So,
yes, thank you so much. I do appreciate all that work, and that in particular I think is a really important category. That moment of transfer is a really important moment.
Right. Board, do you have any questions for Ms. Kornblatt? Okay, thank you for coming. Appreciate your input, and we'll take these into consideration. Thank you.
So I guess Steve Ellis is online now.
Okay. I've just been told Steve Ellis is now online, so we will move to him before we go to Mr. McDonald. Mr. Ellis, are you there?
I am. Thank you very much. Good afternoon, committee members. My name is Steve Ellis, and I'm president of Taxpayers for Common Sense, a national nonpartisan budget watchdog founded in 1995 to ensure taxpayer dollars are spent wisely and transparently. For 3 decades, TCS has supported policies that safeguard the public purse, prevent wasteful subsidies, and promote fiscal accountability and natural resources management. TCS strongly supports Utah's efforts to modernize its bonding requirements. Every oil and gas well eventually stops producing, and every well must be reclaimed. When operators default or delay cleanup, the state relies on that company's bond to pay for reclamation. When the posted bond is insufficient, Utah must cover that shortfall, often drawing from the Orphan Well Fund, which now risks depletion. Outdated bond amounts have left taxpayers exposed across the country. In Utah, current bonds are far below actual reclamation costs, as low as $1,500 for an individual well, even though average plugging costs are nearly 25 times that amount. Current blanket bonds, as low as $15,000, can cover hundreds of wells at a fraction of their true cost. Updating the bonding system is essential to holding operators accountable and protecting state and federal taxpayers from escalating liabilities. TCS strongly supports several key elements of the proposed update. First, while TCS opposes blanket bonds as being an insufficient taxpayer protection, we support the proposal to raise blanket bond minimums. The new amounts are modest compared to reclamation costs and represent an important step toward ensuring operators, not taxpayers or the state's reserve fund, pay for cleanup. Second, TCS supports creating supplemental bonds for higher risk wells. Inactive wells are liabilities waiting to surface. The Utah division found that only 57% of wells shut in for more than a year returned to production. These wells are already well on the edge of becoming uneconomical. They must be properly bonded so operators cover the inevitable costs. We also support barring operators with too many high-risk wells from relying on blanket bonds. Third, TCS supports ensuring adequate bonding immediately after well transfers. Too often, wells near the end of their productive life are passed on to smaller companies that cannot afford reclamation. Eliminating delays and updating bonding prevents those costs from landing on taxpayers. In closing, these updates are not punitive. They are fiscally responsible. Every unreclaimed well today is a potential claim on the public's purse tomorrow. By acting now, Utah can ensure responsible operators remain in the field and clean up costs off the state and federal ledger. Thank you very much for the opportunity to testify today, to speak today.
Thank you, Mr. Ellis. Board, do you have any questions for Mr. Ellis? I don't think we have any questions. I appreciate you calling in to talk to us, and we'll take your thoughts under consideration.
Thank you very much.
Have a good afternoon. Thank you.
You too.
And last but not least, our favorite attorney.
Take that back.
Yeah.
Some of us might abstain from that. But.
So I was going to say.
There's a lot of rippling going on with that comment.
Fred McDonald of Counsel Lear and Lear. I'm providing commentary today on behalf of Utah Petroleum Association, for I serve as counsel on this matter. I'm not going to reiterate a lot of the points that were made. I'm just going to try and supplement a little bit of what was said today and respond to some of that. And I think I want to start off with reminding the board of what Director Thomas started off at the beginning, stating that what is the risk in the state of Utah? We have done an excellent job with dealing with these wells. We are one of the lowest, if not the lowest, in the United States with the problem here that we're trying to address. There is nothing to say that our division and our regulators will not continue that trend. Clearly, the rules that we're working on here today, overall, everybody's in agreement with the concept. We need to up the bonding amounts. We need to put precautions in place. But how far do we have to go with that to address the true risk of what we're talking about? Keep looking at the problem here. We have a minimal problem compared to Texas or Oklahoma or the Appalachians, and I want you to keep that perspective. One of the things as a lawyer that drives me nuts is when you use definitions and you don't capitalize them elsewhere where you're going to use them. So a capitalized term has a different meaning than maybe a general term that's being utilized. And that's one of the problems with these rules is we're not capitalizing, so does at risk at this point mean the same thing as at risk at this point? So from a lawyer standpoint and a drafting standpoint, we've got to be much better with how we're defining things and how it's utilized within the terms. That's one of the things. And I know that the administrative people up on the Capitol, no matter what we come up with, they're going to change it anyways. So just to keep that in perspective. But one of the things that were brought up today was, okay, how do you deal with these ducts or drilled but not completed situation? With the same situation, what does the division define as an inactive well? What does define as a drilling operation suspended? And we're getting confused by those terms. And so if we're going to include those terms as part of what constitutes an at-risk well or doesn't constitute an at-risk well, those definitions need to be up front as well. On the issue of the shut-in temporary abandoned thing, this is, again, a very big point for the UPA members. Under the process, if you're shut in or temporarily abandoned, you get 12 months. Then you have to file an application justifying why further extension is allowed, and that's on a year-by-year basis. As part of that justification, if the division wants to have and say, what is your bonding level for this well, or whatever, they have that opportunity. In addition to the fact that there's a mechanical integrity test that has to be done in order to ensure that the health and environment is protected. That's the risk we're talking about. So when UPA is asking for an exemption of shut-in temporary abandoned wells that are approved by the division, that is appropriate because that is not truly an at-risk well anymore if the division has made the justification is satisfactory. And keep in mind that that only lasts for a total of 5 years. At the year of 5 years, you have to plug and abandon the well. I also want to address the issue that they brought up about low producing wells. You've heard testimony by a company like Bayless that said that's part of their business plan, that they come in and take over those wells because they're still producing. They have opportunity to produce. And at that point in time, that operator has to go through this process. And if they can't meet the bonding requirements, the bond's going to be higher anyways at that point. So you want to still encourage the transfer of low producing wells to some as part of some of their business plan. And there are adequate protections when that transfer occurs to take care of that operator to make sure it has the ability to meet its obligations of if the well is going to be plugged and abandoned. On the issue also of the exemptions for each tier of being 20, 13, and 8%. One of the things we want to clarify, because it's not clear to me right now, and obviously with the calculator just coming out yesterday, I'm not sure if it's been calculated as part of that, is that we put in the supplemental bonding table that it's the number of wells that are non-exempt. So in other words, if you're exempting 20%, then only the wells that are the other 80% need to be accounted for, or whatever in that amount. And so that's a very important clarification that needs to be done to carry through that concept. If you're going to exempt that amount, then that should not be part of the supplemental bond required. I think with that, obviously as we get into the formal rulemaking and we see what the formal rule is with consideration of all the things that have been said today, we'll have more commentary and presentation on it. But again, I do want to emphasize and agree that overall I think we're in agreement here with the process that we're doing, overall the concepts that are there. We certainly appreciate all the input and division efforts and the board's time for doing this. And overall, again, I think we're on the right track. But there are some tweaks that need to be done to make this fair and continuing that balance that Mr. Simonson just mentioned about the protection of the environment and the state, in both from liability and the environmental and health and safety issues, and yet carrying out the legislative mandate that we maximize natural resource development in a way that we continue to make Utah attractive to the oil and gas industry to come here and develop those resources. Thank you for your time.
Thank you. Couple questions. Do you think that 20/80 split on tier 1 is defined? The tier, the 20% exemption. Do you think that's clearly defined in the rules as they are right now?
I think there's some tweaking that needs to be done on that, but I thought that the change that the division made in the last draft up front was correct. It just didn't get transferred to the tables.
Okay. And I'll tell you, when it goes to rulemaking, they will take out all capitals.
I know, but
Which
But
is
again, if the
frustrating.
term is going to be
know.
utilized, we got to make sure it's the same term that's being used in the definition.
It is frustrating, but they will do that.
I know, I've experienced that before.
Board, do you have any questions for Mr. McDonald? Mr. Moon?
Do you think the current rule as drafted adequately addresses transfer of, marginal wells to potentially undercapitalized producers?
What I will tell you is we have not heard any feedback from our members that would lead me to believe that there's a concern there with that. But I'm going to defer more to Ms. Renko Browning or one of the members if that's the issue.
Mr. Galecki?
Mr. McDonald, at this point, testimony and such, I don't see any major roadblocks at this point. Do you see any really contentious issues that have? I mean, everything thus far has been.
Overall, the concept, yes, but it's these tweaking and make sure we're in agreement on it, and so that if the rule is carried out, are we all interpreting it the same way, which is a big concern right now. That's one of the biggest issues about using this calculator now, is the calculator carrying out exactly what each of the shareholders or stakeholders agree that's how it's supposed to be.
But if we were to start rule making at this point, do you see any issue of getting?
Again, the proof is in the pudding of the way it's written, and if it comes out the same way, or if there's adjustments to be made, then it may be that when you go to formal rulemaking and you have the hearing on that, there may be additional issues that are raised.
Do we have any other comments?
Yeah, I share your consternation about capital, or the capitals. In particular, as you read this thing, I think division, board, operator ought to be defined and out there. Do you have another suggestion on how we might do that so that when it gets up to the library scientist person?
Well, it's hard. I think if the agencies and the boards tell the administrative rules group that this is a concern, as a contract drafter, I always make sure we have defined terms and it's capitalized so that there's no question about what the definition is that applies in that spot.
Natasha is here. Maybe we can ask her. She's the one who submits these.
Hi, I'm Natasha Balliff, the Legislative and Planning Coordinator for the division. The Office of Administrative Rules has actually, in the last, I want to say year to 2 years, has changed their process a little bit, and instead of the review going up to the governor's office, they still do a review, they just aren't as critical of it as they have in the past. It's actually the Office of Administrative Rules doing the review. They place a lot more decision-making in the divisions and offices that are creating rules, and so if there are definitions that we specifically want capitalized,
They will allow you to do that? Okay, that's good to know. That's a change.
If I may add one more thing, getting back to Mr. Galecki's question, the issue of the shut-in and temporary abandon and the definitions of, drilled but not completed, those kind of things are still major issues for some of our members. So we've got to get that clarification. So,
Good deal. Do we have any other questions? Thank you, Mr. McDonald. Ms. Browning, do you have any? You look like you might have some final thoughts.
I thought I was out of the hot seat. No, I did just want to have that additional comment to Mr. Galecki's question that we do still have concerns with some of the wells being included as at-risk wells, as Mr. McDonald just said. Beyond that, I think, there are some opportunities for improvement. We know that not everyone is going to be happy with this, but that is a big concern for us, outstanding.
Thank you. Thank you. Now, we do have some people who didn't register for 15 minutes, but wanted to speak. Oh, Mr. Sorensen, you're there. Oh, we've taken care of everyone.
Was there anyone else?
Is there anyone else in the audience who'd like to speak before we conclude the? Seeing none. Board, I think taking everything into account, we need to deliberate for a few minutes to decide how we're going to proceed. Give us maybe 15 minutes or so. We'll try to be back in that time frame. Oh,
That's one question. The same question that I posed to Fred. Would you guys like to comment on that? Is the current bonding or the current rules as written, do they adequately address operator change? In your opinion?
Yeah, I think they do, in particular by having this limitation that if you have a certain percentage of your wells that are at risk, then you can't get a blanket bond. So it does it, in addition to the explicit language on well transfer, it does that implicitly, which I think is very clever, for lack of a better phrase.
Okay. It was just mentioned a lot of times, and so I was wondering if
Yeah.
you want something changed
think-
or if you're okay with
I
it.
think the big thing to clarify, I mean, in addition to the stuff that people have brought up, exactly what the 2013-8 exemption, how that works, exactly what class of wells is being exempted. Is it the percentage of your total wells, or is it a percentage of your at-risk wells, which can be on the blanket bond? I think there may be less clarity on that than even we think. So I would make sure to get that one straight.
okay.
Thank you.
Before we move into deliberation, Natasha, could I have you come forward? Let's talk about the process for formal rulemaking. Once the board wants to go to formal rulemaking, what happens exactly?
I will submit it to the Office of Administrative Rules. They publish on either the 1st or the 15th of the month for the comment period to open. So I have to submit it beforehand. So say I submit it on the 15th of December, that means the comment period would open in January.
Okay.
We have to have a minimum of 30 days for the comment period. We could have it up to just under 120 days. They have a 6-month window that you can get it done in. Yeah, from there we'd have the 30-day comment period. We'd have a 7-day window to consider all the comments. And then from there, if we want to make any changes, if it's over, I think it's 15 words and they're substantial, then we have to do another 30-day comment period, which should also be taken into consideration within that 6-month window. If there are no changes, then we just file a notice of effective date and they become effective.
And I thought I heard someone out here mention a hearing. Is there a hearing connected with this, or it just goes through the comment period?
There is, you can have a public hearing attached to it. You don't have to. So we could have another public comment or another public hearing. We used to do that years ago. And then we just kind of, I can't remember exactly when, but we just decided to move forward and go with the comments. And if we needed a public hearing, we could open it back up. Anyone can actually request a public hearing. You just have to have, I can't remember if it's 10 people or 15 people, but you have to send in written requests for a public hearing for
Okay.
it. So that is something that we can incorporate if you guys would like. And in the past, I've had that in conjunction with board hearings, so it's not like an additional meeting that we have to have.
But you haven't done that for some of the other rulemaking that's happened in the past?
We haven't
year?
done it for a couple of years. I want to
Okay.
say maybe before 2019.
But none of the things that have occurred this year for formal rulemaking?
Yeah, all of the formal rulemaking that I've done since then has just been a comment period, and if people are interested in a public hearing, they could reach out, but since then I've never had someone reach
Okay.
out and request one.
Okay. All right, board, can we deliberate?
Can I get a clarification then? So say we come back and we say, okay, go for it, formal rulemaking period. We'd have a 30-day comment period that wouldn't start until January.
Right.
And so it's really a 45, 60-day comment period or something like that. So that gives people more time to, because it's the holidays and who wants to be bothered with this stuff?
Yeah, so it is, at least with the formal public comment period, it is strict. So if it opens on January 1st, it will then close on whatever day we say. And that's something that I list the day, so we can have it be exactly 30 days. We could have it end on like a Friday. There's something else I was going to say about that.
So we
and I
could say,
lost it.
okay, start now, January 1st is the beginning of the comment period, February 1st would be the end of the comment period, and so that gives people all that amount of time to?
Yes, yes. So we would have 30 days for it. And if that was something we do open it, say on January 1st, if you do want to have a public hearing, we could incorporate that into the January board hearing. And then the only thing is that you can't have a public hearing and then also make the rule become effective. You would have to wait until the next month for it. I remembered what I was going to say. Because we have a board, because there is a board of oil, gas, and mining, we actually have this added step of getting board approval. Other divisions that don't have boards don't have that, and so they can have a 30-day comment period and then the 7-day consideration for comments and then make it effective. The kind of delay here is just that we have to accommodate the board schedule.
So we would have to we wouldn't be able to approve it until February.
If you wanted to have
if we were doing a strict period.
Yes.
Okay.
Yep, even with a public hearing, we would still
Okay.
Have them effective in February.
Okay, good. Any other questions before we retire? All right, we'll get back as soon as we can here. Try to hold it to 15 minutes, but I have my fingers crossed.
1. Okay, you're good to go now.
We're back on the record. Before we look for a motion, I'd just like to thank everyone who's come today and presented. We appreciate your input, and we'll review all of the comments that have been made today. Thank you for coming, and I want to ask for a motion.
Madam Chair, I'd like to make a motion that the board directs the Division of Oil, Gas, and Mining to enter formal rulemaking. The division is to consider all the comments made today, although we invite all commenters to submit their comments in writing to the division. The comment period will begin on January 1st, 2026.
Do I have a second?
Second.
It's been moved and seconded. All in favor, please say aye.
Aye.
Any opposed? Thank you. Motion carries.
Thank you, members of the board. I appreciate it. And for clarity, it's a 45-day comment period. Thank you.
Thank you. And with that,
Make a motion, we adjourn
second?
for the year.
Moved and second, we're adjourned. And I'd like to say thank you to everyone. This was my final meeting. Mr. Walker, as chair. Mr. Walker has officially taken over as chairman.